Here, Court of Appeals is now in session. The Honorable Mark T. Boonsborough, the Honorable Brock A. Schwartzel, and presiding Honorable Thomas C. Cameron. All persons have business here and draw near, give attention and shall be heard. God save the United States, state of Michigan, is on the court, please be seated.
Well, good morning, everyone. Welcome to our second and last day of hearing cases here in Lansing. On behalf of Judge Boonstra and Judge Schwartzel, welcome. Just a few items before we begin. I would note that we have a lot of experienced appellate attorneys here. I have to remind you about your time or that we've read the facts. I'd encourage you all to jump to the one or two issues that you think the case really turns on. And then finally, I'd note that because this is being recorded, please do not indicate any children's name to protect their identity. So with that, why don't we move directly to the first case? Which is item number 14, People of the State of Michigan versus Morrison. That's item number 364651.
Good morning, Your Honor. It's Michael Frone on behalf of Joseph Morrison.
Mr. Frone, can I just interrupt you just for a moment? I know Mr. Pallas was scheduled to join us remotely. I don't see him on the screen. Let's see what the delay is. There he is, Mr. Pallas. How are you? You're muted. You're muted, which is fine. But when it's your time up, just be sure to unmute yourself.
Absolutely, Your Honor. Thank you.
Mr. Frone, go right ahead.
We'll get 5 cases in front of you today. If we include, there's a cross appeal. That's a record for me. I've never had 4 cases in front of the court. Might be a record for the court.
We've already declared it Michael Frone Day. Just so
it is. All right. I have to ask, Dwight. I don't know if that's good or bad, but we'll get through it. Is it still 15 minutes, even though there's a cross appeal? So with that in mind, I'll try to reserve 5 minutes for rebuttal. It's an unusual case in many respects, including that, they transferred these guys hundreds of miles out of the state at the beginning. I will say, just to sort of square the circle on that, because your colleague, Judge Yates, was very helpful in bringing that court of claims case to an end, as was Judge Wilson in the circuit court. Since Mr. Morrison's been returned to the MDOC, we don't have any complaints about the MDOC whatsoever. He's been treated fairly. He hasn't given them any reason to be a problem. He hasn't been a security threat. He's a model inmate. All he does is read. His goal in life is to be an Orthodox priest. I mean, that's the real Joseph Morrison. I've tried to convey in my briefing that the real Joseph Morrison's not what was portrayed in the media, although more importantly in the, at trial. And so that was unusual. That's been resolved, and we have no complaints about the Department of Corrections since Mr. Morrison's returned to Michigan. The case is unusual in a number of respects. I'll just to be candid, just to be to the point, I've never seen a trial more violative of due process than this one. Our anti-terrorism statutes required proof beyond a reasonable doubt that Mr. Morrison provided material support to Mr. Croft and Fox. They were the named terrorists, not Mr. Musical. So there's a lot of, especially in reference to the new theory being brought up that this was a murder plot. Well, if we look at their evidence, it's all conversations internal. It's not even from Mr. Morrison. It's comments.
Mr. Frone, would you mind focusing on the question of whether kidnapping is a valid predicate felony under this terrorism statute?
It isn't. The term violent felony is defined in the statute. And if we look at that section of the statute, it doesn't meet the definition. In fact, this court's held repeatedly, kidnapping requires force. That's an element of kidnapping.
Do we look at this in a categorical way in terms of looking at the elements of the charge? Because I say that because, I mean, kidnapping in the usual instance will be very violent. And so you can definitely see, and I would say most instances of kidnapping would be very violent, extreme force. But do we look at this? Do we just look at the elements of the crime? And if force is not a necessary element, then it's not a violent felony?
We do. That's the way this court's always analyzed these issues. Whenever the courts looked at statutory language. That's what we're doing here. We're looking at the offense elements. They're defined in the statute. The court's always applied an abstract elements test. It's always looked at the offenses abstractly. It's always looked at other case law, which defines the elements. The case law here defines kidnapping as requiring force. I'm sorry, it's not requiring force. It's not an element of the offense.
How do you commit a kidnapping without force? I mean, I find that just an interesting question.
It is. I've been on the other end of it. I've been on the other side of it. And the court's always said when I had a case in front of this court in Kent County. And I remember arguing, I don't believe any of you were on the panel. I remember, Judge Letica saying to me, are you saying that force is an element of kidnapping? And I had to say, no, it wasn't, because in that particular case, it was an unusual case. It wasn't clear force was used. I don't want to get into the details of it, but it can happen. The victim was in the car with the defendant parks the car. It was an unusual case. And in fact, the prosecution in that case, Kent County prosecutor, was not arguing that force was involved. And I couldn't argue that a kidnapping didn't occur because force wasn't involved, because force is not an element of kidnapping. And so I've been on the opposite end of that argument. I've lost. And that's all we're asking for here, is to have the same standard applied as I've always applied. And I have to say that there was a recognition by the district court and the circuit court that this was a problem. Judge Wilson's absolutely incorrect, not knowingly. I don't think he knew that he was wrong, but he's absolutely incorrect when he said to me during the motion hearing on this, shouldn't this issue of the problem with the kidnapping statute have been raised before trial? And I have to admit, my response to him wasn't very good. I was kind of taken aback because it was a sufficiency of the evidence argument. It is. There's no preservation requirement. My response wasn't very good. And then, opposing counsel, he's not intentionally misrepresenting this either. He's picking up in his brief, he picked up on what Judge Wilson was arguing there, and he made the same argument. He's making a preservation argument. This was addressed. This was brought up. If you go back and look at the district court transcripts, and we discussed this in our reply brief, they knew this was a problem. And the district court judge, it's discussed in our reply brief, he cites Quigley. They discussed the Quigley case. And he says, the district court judge basically reasons, well, it doesn't matter. Maybe kidnapping is a problem. And again, I'm paraphrasing. Maybe it's a problem, but they were a general threat. And there was this boogaloo. That was the felony. There's no felony boogaloo in Michigan, by the way. That doesn't work, because that seems to be their argument from this court as well. So does it really matter? And they kind of gloss over it. And then we get in front of the circuit court. That time, it's admittedly post-conviction. Judge Wilson reasons the same way. If you look at the written opinion, maybe kidnapping, maybe there's a problem with kidnapping, but there was a general threat. They were up to no good. They were plotting a boogaloo, and that's good enough. Well, it's not good enough. We have to, the statute.
A moment ago, this case is, your theory is a sufficiency argument. But isn't it really a defective jury instruction?
Well, it's both. We raised both. Issue one, sufficiency of the evidence. Issue two, really the same issue, jury instruction.
To follow up on Judge Cameron's point, I think the way I read the record, there was plenty of evidence of kidnapping. Plenty of evidence. So I don't see how a sufficiency of the evidence claim would satisfy that. The jury instruction question makes more sense, at least to me.
Well, I respectfully would disagree a little bit on that. I agree that it's somewhat unusual sufficiency of the evidence argument. Typically, they involve a defense attorney asking the court to reweigh the evidence. We're not doing that. And I'm not disagreeing with you.
Okay.
That on the weight, that there wasn't enough weight to bring this kidnapping claim to the jury. So, but People v. Prude from Michigan Supreme Court says that in some sufficiency of the evidence arguments, the court is really looking at their legal questions. There's no evidence of the weighing in our argument as regards to the kidnapping claim. There's no request on our part asking this court to weigh the evidence. It's a legal question.
So if we were to agree with you with regard to this kidnapping and statutory analysis, what is the relief you're looking for? Because under a sufficiency, typically double jeopardy would apply, but under just a jury instruction problem, double jeopardy would not apply.
Right. Right. In fact, Quigley is a little unusual, because Quigley, the court actually, actually held the case could be retried. It couldn't be retried on the argument that, went to that case kidnapping, and in our case kidnapping. But if the prosecution had a different theory, I hate to use the word theory because that gets us into issue 2. These were really acts, not theories. Had a different theory they could bring. They could retry the case on that. So double jeopardy would attach as to the kidnapping argument. But if you were to reverse on issue 2, it could be retried.
What about, just getting back to the statutory analysis? I think the prosecution points out that the second element of an act of terrorism specifically includes kidnapping. And so if we were to agree with you, we'd just be ignoring what the legislature put in that second element?
No,
Okay,
no,
why?
that's United States versus Nieder, United States Supreme Court case, which involved, I don't have the language in mind, involved mail fraud. And so, I mean, it's right on point with this. It had element A, element B. Element B didn't work, just like kidnapping doesn't work. Element C defined, included the offense. It didn't satisfy element B, but yet if you looked at element C, the statute specifically named it. That's exactly what's happening here. And the United States Supreme Court said, no, that's the fact that for whatever reason, the legislature named kidnapping here, kidnapping in element C, doesn't mean we get to ignore element B. B is still there.
I think at the time they included kidnapping as element B in that section of the statute. The kidnapping statute did require force.
Oh,
But the kidnapping statute was later amended to remove that and put it into unlawful imprisonment, I believe, in 2006.
2006.
Yes.
All right. Well, I don't have that. I can't agree or disagree with that. I don't have that memory of it, but at the time this case was tried, that's what matters. And we don't go back and look at, the statute. So that might be the explanation. But at the time this case was tried, violent felony, it did not include kidnapping. And they knew that was a problem because this was discussed in the district court, and yet that was the argument that was made at trial repeatedly. Now, post-conviction, there's an effort to shift away from that and say, well, this is really about other things. It's too late to do that. And I would say, why would they have focused so much on kidnapping when they knew there was this argument was made in the district court? Why? The answer is the other theories are worse for them, more implausible. There's no evidence Mr. Morrison conspired with Croft and Fox to murder anyone. Now, that's the argument now. He conspired with them to murder police. Well, let's look at the record. There were meetings, events that occurred out of state and in state, which Mr. Morrison avoided because he knew police would be there. Mr. Morrison was pulled over. They had their phones set up so they could ping each other and get.
What about,
would
would blowing up a bridge, would that satisfy
it would.
statute?
It would. But the problem with that, and murder, just like it would satisfy the statute, just as murder would. The problem with blowing up a bridge is where's the evidence that Mr. Morrison knowingly lent support to Mr. Croft and Fox to blow up a bridge? It doesn't exist. The blowing up a bridge talk occurs, when he's gone. He's basically checked out of the Watchman. And the FBI has given up on the Watchman, given up on Morrison. That's where the bridge, and by the way, even that, what is the evidence that there was a serious plot to blow up a bridge? I mean, they had fireworks. That's what they had. They had the FBI saying to the Watchman, we can get CO2, we just need money. Watchman never came forward with a dime. There's really no evidence that there was any talk that, then I say Watchmen, of course, I'm referring to them collectively, not, none of them came up with any evidence or any money to buy these explosives. So I don't think there's really even a case to be made that they were plotting that anybody was plotting to blow up a bridge at that point in time. That happens later, later in the, after Mr. Morrison's basically gone. So I don't know if I need to address the claim, Mr. Agent and Pola's opinions. They're not a substitute for evidence. The arguments, if you look at their brief, there's a lot of quoting for opening, closing statements. Those aren't evidence. That's not evidence. Jury instructions aren't evidence. When we look at the evidence, it was a kidnapping case. They had evidence that there was a plot to kidnap the governor. No one's disputing that. Under traditional sufficiency of the evidence argument, they'd be fine in their position. Problem is kidnapping, it's a statutory interpretation argument that's a problem here. It doesn't meet the definition of violent felony. And I keep citing Quigley and their response, well, Quigley's unpublished, that's true. And I sometimes hate to quote unpublished opinions because it sounds like I'm relying on I'm not relying on unpublished opinion. I'm relying on the reasoning. There's a reasoning in Quigley, and if we read, Quigley, as I know the court has, and we track its reasoning, it applies perfectly to this case. It's indistinguishable from this case in that regard. I briefed on issue 2, involving the unanimity instruction, the failure to give a unanimity instruction. The Cook's decision was not followed in this case, and it was ineffective assistance for trial counsel to not request a unanimity instruction. And here's because Cook's states that a general instruction is sufficient unless you have separate and distinct offenses which are going to the jury, and we have that here. Now, the prosecution says Gadomski. Gadomski involved theories, not acts. Murder, kidnapping, blowing up a bridge. Those are acts. Those aren't theories. They are, we can see this in the briefing when we talk about the supposed murder plot. It's one line of, certain lines of testimony. Talk about the kidnapping, other lines of testimony. But they're separate, distinct.
I don't know that I follow your distinction between theory and acts, because all of this, you could say it was a theory that had to be proven to show that an act took place. I mean, you can have theories of acts, just as you can have theories of motives. It's just, it's the story of whether this evidence shows that an act took place. So I don't follow the distinction you're trying to make there.
Theories would be in Gadomski. That's the case that the prosecution relies upon. What was Gadomski? It was a criminal sexual conduct case. It involved theories, as we often see in CSC cases. Relationship between the parties. That's not an act. That's a theory. The age of the parties. That's not an act. That's a theory that the prosecution went forward on. In addition, in Gadomski, the statute listed these as alternatives. They're right there in the statute. Kidnapping, if we look at violent felony, it just says violent felony. They're not listed out. But age, relationship, those are theories. Murder, kidnapping, those are acts. And so I think that's the distinction. I think if we're going to apply from Crooks, this distinction that the Michigan Supreme Court made in Crooks between theories and acts, that's the way to think of it. Gadomski's helpful in that regard, because Gadomski was a case that did define or apply a situation that involved theories. And then there's other cases, again, they may be unpublished, that I cited, felony murder cases where different acts were alleged. Larceny, I think the case I cited involved larceny from a building and robbery or something. Those are acts. And this court said, to that situation, Crooks applies. Unanimity instruction was required. We cite those cases in our brief. That's on point with what we have here. Blowing up a bridge, murder, kidnapping, those are acts. That's why unanimity instruction was so critical, should have been read. And, but this is a case where there were no defense instructions. There was there was a lot of instruction, and you can't apply an entrapment there were no defense instructions. I don't have an explanation for that. And I think it was, as much as I don't like arguing it because I do believe trial counsel was kind of overwhelmed in this case. We look at the amount of discovery and everything else. I do think they dropped the ball in not requesting a unanimity instruction, and it's satisfying both prongs of Strickland. We don't have a fair trial. We can't know this is unit. I mean, we're appearing on appeal all these years later, and they're arguing different theories, or what I'm calling under crooks, different acts. How could the jury have possibly been making these distinctions when they went back to deliberate? It's very possible to imagine a jury said, all right, maybe multiple juries said, okay, they proved kidnapping. There's one juror, a couple of jurors that said, oh, I don't know about kidnapping. Something about that bothers me. But man, there was this boogaloo and there was a talk about murder. So
I think we've got
Should-
it.
should-
Why don't you,
Right.
I'm interested to hear from the prosecution. You've got
Sure.
plenty of time in rebuttal.
Okay, briefly, just to, the sentencing issue. I want to say this, Judge Wilson's gone. So they're asking the court to remand this case to the circuit court, directing a new judge who knows nothing about this case, to find reasons to justify a consecutive term, which Judge Wilson, they repeatedly asked Judge Wilson to impose a consecutive term. Judge Wilson repeatedly said no. Emphatically, they filed a motion for reconsideration. He actually seemed to be offended by it. And now they're asking, that's sentencing at the appellate level. It would violate the norms of this court. And I'll say that about the sentencing issue. Thank you.
All right, thank you. All right, Mr. Palace.
Good morning, Your Honors. Brother Counsel, Mr. Ferrone. I'm John Pallas, Assistant Attorney General, representing the people of the state of Michigan in this case. We are the plaintiff appellee here, as well as the cross appellant on one issue. It is my pleasure and honor to be here today arguing for the state of Michigan and asking for affirmance of defendant Joe Morrison's convictions and for a remand on Morrison's sentence as cross appellant. This is no doubt a complex case. At least 3 weeks of trial, months of pretrial practice, months of post-conviction proceedings, an incredible amount of work in addition by the FBI, the Michigan State Police, and other law enforcement agencies. It wasn't an easy case. I can say that because I was involved in it from almost the beginning. And the times during which these events at issue occurred were unlike any other time in the history of this country. The COVID pandemic and all the personal, political, and social upheaval that accompanied it. But having said that, the 3 defendants in this case, including defendant Morrison, received a fair trial, which is what they were entitled to. A jury of 12 of their peers found them guilty beyond a reasonable doubt of the charges against them.
Mr. Pallas, is kidnapping a violent felony under the statute?
Yes, it is.
How?
Well, the act of terrorism, that's where we get involved here, is defined in part as an act that would be a violent felony under the laws of the state, whether or not committed in this state. The statute itself defines a violent felony in part, and I'm talking about the actual terrorism statute, as, quote, a felony in which an element is the use, attempted use, or threatened use of physical force against an individual, and then goes on to list other forms of force like biological, chemical, radioactive, explosive, incendiary.
Is force a necessary element of the kidnapping statute?
Yes. This type of kidnapping, yes. There are multiple forms of kidnapping. And there isn't any published Court of Appeals authority, as Brother Counsel candidly admitted, that provides a direct answer to this question. There is the one unpublished case which addresses the issue, People versus Quigley, but that opinion is just plain wrong. You have to look at the kidnapping statute itself, taking a look at it. The kidnapping statute says that, quote, a person commits the crime of kidnapping if he or she knowingly restrains another person. And then there's a number of alternative intents. MCL 75349 subsection 2 defines restraint as, quote, restricting a person's movements or to, quote, confine the person so as to interfere with that person's liberty. My question is this: how does one restrict or confine someone without the use of force? It's just not possible. The panel in Quigley tried to contrast the kidnapping statute with the unlawful imprisonment statute by saying that the latter, that being the unlawful imprisonment statute, specifically says that one forcibly restricts or forcibly restrains a person. But in our opinion, the word forcibly is unnecessary. Again, how do you restrict or confine someone without using some sort of force in the first place? It's
Mr.
simply not.
Alice, I had a case just last month involving a CSC. And the argument was, and it was a question of whether to affirm the bind over, and we did, where essentially the restraint was intimidation, that this young boy was afraid to leave because of the circumstances he was presented with. And there was little, if any, anything that could have been described as force. So I'm not sure you're right about that. And I guess I would invite your response to the point I made earlier. Would you agree with me that in 2006, the legislature removed from the kidnapping statute all references to force? Now, you may say because it wasn't necessary, but they created a new statute on unlawful imprisonment, which is where they embodied the force element. They took it out of the kidnapping element.
I don't disagree with you, Your Honor, on that point, in that what occurred in
All right, Mr.
2006.
Palace, Mr. Palace, this is one of the issues about remote oral argument. Did you say you agreed or disagreed?
I agreed. I apologize.
Okay.
So
So you agree with Judge Boonstra, so what does that mean for your argument?
well, what it means is that it's a change without meaning that occurred, because simply that what's left of the
Does the
kidnapping.
legislature do that very often? They like to change things without meaning anything?
Well, I've seen a lot happen like that, unfortunately. And here there's a circumstance where what was left in the kidnapping statute was talking about restriction and confining. And that is what exactly occurred here, which would include force.
Mr. Palace, what I'm
Yes.
struggling with is the legislature defined what a violent felony is, and it defined it as a felony in which an element is the use of attempted use or threatened use, and it goes on and on. It uses the word an element. You seem to be arguing that, well, look at the felony, and if it has force or there's some violence involved, it qualifies. We don't need to look at the elements, just look at the surrounding circumstances of the felony. That can get you there. Am I mischaracterizing your argument?
Not exactly mischaracterizing my argument. I think that the kidnapping statute talks about knowingly restrains a person, and restraint is defined as restricting a person's movements, or to confine the person so as to interfere with that person's liberty. I would say that a reasonable interpretation of that statute is that there is force required under those circumstances. And one of the things that I wanted to talk about as well, and this was brought up a little bit earlier by one of you, that if kidnapping were not a violent felony, why is it even cited in another portion of the definition of act of terrorism? But other things to look at when trying to figure out what all of this means, and in addition to ignoring the use of the kidnapping offense in other parts of Michigan's anti-terrorism statute, the panel in Quigley also ignored the similarities between the state and federal versions of the anti-terrorism statute. In fact, as this court has found in People versus Bizek, which is a 2021 published case, the state version of the terrorism statute largely mirrors that of the federal version. And
I don't understand why the terrorism statute, our terrorism statute, paralleling the federal statute means anything, because the terrorism statute tells us to go look at the kidnapping statute. That's the key that we have to look at. And, the federal kidnapping statute is completely different than ours. Don't we just have to look at our Michigan kidnapping statute to determine whether that's a violent felony or not?
I don't think so, Your Honor. I think that looking at what the federal system did in terms of their anti-terrorism statute, they definitely referred repeatedly during the course of that statute to the offense, the federal offense of kidnapping. So I think that might be some indication, since there's so much duplication of language between the state and the federal versions of the anti-terrorism statute, that why would the state legislature have implicitly excluded kidnapping from the state version of the anti-terrorism statutes, when in fact they were adopting in large part the language of the federal anti-terrorism statute. And one other thing that I wanted to point out with respect to this issue is that we have the Michigan criminal jury instructions. Now, I realize that those are not the standard state criminal jury instructions, do not have the force of law, yet they are another window into what the state offense of kidnapping involves. And certainly depending on the type of kidnapping contemplated, whether it's hostage/murder, extorting money or other valuables, planned secret confinement of the victim, holding the victim for labor or services, and so on, kidnapping is indeed a violent felony, and force is something that a jury must find in order to convict a defendant of kidnapping under those specific elements as laid out in the Michigan criminal jury instructions.
Mr. Pallas, Mr.
Yes.
Pallas, let me probe that just a little bit if I could. Would you agree with me that those model criminal jury instructions are patterned after the original kidnapping statute of 2002? In fact, use the precise language from the subsections of that statute, which today no longer exist because that statute was amended in 2006 and did away with all that. Now, I once chaired the Model Civil Jury Instructions Committee for many years. I appreciate that sometimes they don't keep up with the law. But isn't this an example of where the model criminal jury instructions haven't kept up with the change in the law, and that those criminal jury instructions that you're referring to are not only a statement of law, they are no longer reflective of the current statute?
Well, I would disagree with that because, again, as I would argue that there has to be some force just by the definition of kidnapping itself, just by looking at the definition of kidnapping, by looking at the definition of restraint. Now, I honestly can't say what is in the minds of the people that have updated the Michigan criminal jury instructions. That may be the case, but I don't believe it is. I think that those particular phrases were intentionally left in the statute criminal jury instructions.
Mr. Pallas, if we disagree with you with regard to whether kidnapping is a violent felony, does that mean this has to go back for a new trial, or should we otherwise affirm on some other ground?
That was exactly the point I was getting to, Judge, actually. If for some reason this panel follows quickly and takes that interpretation of the kidnapping statute, there are very strong reasons why it would not require reversal of Morrison's conviction. And that is because, as sort of has been suggested by Brother Counsel, and he's correct about this, kidnapping was not the only planned felony the jury considered when deciding whether or not Morrison and his co-defendants provided material support or resources for a terrorist plot. Unlike the jury in Quigley, the jury in this case also considered evidence presented on, and they were instructed on, other felonies that could serve as the violent felony for purposes of establishing a terroristic act. My understanding of the way that the Quigley case went along, they were just read that the only possible felony that could be involved there was kidnapping. That was not how that was not what occurred here. In fact, when he was instructing the jury at the very conclusion of the trial judge here mentioned other felonies in his final instructions to the jury. For example, murder, assault with intent to commit murder, assault with intent to commit murder, Excuse me, I have that duplicated. Assault with intent to commit great bodily harm, arson, and kidnapping are violent felonies. So I think as long as we have sufficient evidence as to one of those types of felonies, then this does not have to be reversed, even if this court were to follow quickly and find that kidnapping is not a violent felony.
Well, Mr. Pallas, so if kidnapping was not properly a predicate offense and therefore was not properly included in the jury instruction, but yet it was included in the jury instruction as one of the acts or theories or whatever you want to call it, underlying the conviction, how do we know to what extent, if any, the jury or individual jurors relied on the kidnapping evidence to sustain the conviction as opposed to one of the other acts or theories?
Well, that kind of goes actually.
Doesn't that taint the entire verdict, the fact that they did or could have based it, at least in part, on kidnapping?
I don't believe so, Judge Boonstra. And the reason I say that relates to the jury unanimity issue that Mr. Ferroni raises. There's an issue as to whether or not there should have been a specific jury unanimity instruction, in part for reasons that you are suggesting here. He complains that as there were multiple acts or felonies presented, he calls them acts, kidnapping, murder, assault, etc., that could have constituted the violent felony, which makes the act of terrorism. This was a multi-act situation which required the giving of a special unanimity instruction. There's a problem, though, several problems. Morrison did not object to the instructions as given. He expressed satisfaction with the instructions, waiving any claim of error. But even under plain error review, review for ineffective assistance of counsel, review on the merits, Morrison's claim doesn't get him anywhere. This is because the providing material support or resources for a terroristic act is, on the facts of this case, a multiple theory statute, meaning that a specific unanimity instruction wasn't required. But even if
Don't understand that. Can you explain what you just said?
Well, there's a distinction between multiple act cases and multiple theory cases. And in multiple act situations, there is case law, and I believe it's the Cook's case that Brother Counsel was mentioning, that talks about there being a requirement for a jury unanimity instruction in a situation where multiple acts are being presented to a jury. We're arguing that this is a multiple theory case, but even if this were a multiple act case, the failure to give a specific unanimity instruction on the elements of this statute would not be a problem, because this case falls within two exceptions to the jury unanimity requirement. The multiple acts, and let's just assume, and I'm saying multiple acts just for sake of argument, they were not materially distinct. They were all part of a singular plan to initiate the Boogaloo or Civil War within the United States, and in Michigan in particular. And there was no reason to believe that the jury in this case was confused or disagreed about the factual basis of Morrison's guilt. In fact, the deliberations that occurred in this case were relatively short for a trial of this length, and the jury had few questions. There's also something called the continuous conduct exception to the requirement of a specific unanimity instruction. Even where multiple acts are presented as evidence of a single criminal offense. Two circumstances: when the two offenses are so closely related in time that they form part of one transaction, or when the offense consists of a continuous course of conduct. At a minimum here, the various offenses that underlie what could have been the various terrorist acts that were being discussed here, at a minimum, they constitute a continuous course of conduct, making a jury unanimity instruction unnecessary. So for that very same reason, we would say that that a jury unanimity instruction was not required on the facts of this case.
How do we know that the jury didn't evaluate all of the evidence and say, you know, there really wasn't enough evidence of a murder plot, and the blowing up the bridge, that was after Morrison was involved. But we're going to convict him solely on the predicate offense of kidnapping. How do we know that that's not what they did?
Well,
And if
if
that
we're
is what they did, it plainly was improper if kidnapping isn't the proper predicate offense.
Well, again, it depends on whether the offense is considered a multiple act offense or a multiple theory offense. If it's multiple act, I would say you may have a point. But we have the two exceptions that I just got through discussing, which says in those circumstances, I mean, we never know. There's lots of juries that have situations that they are presented with that juries don't have to agree on every single fact that they are presented with. Rather, they need to agree on the key elements of the offense that's being charged. And as long as they are finding that there was indeed an act of terrorism here, if we
Alice?
treat this as, yes.
You're saying that these are acts, not theories. But these, whether it's murder or kidnapping, those are both criminal offenses independently. Those are independent crimes based on acts. So I'm wondering if you can think of a different statute that are acts, not theories, which are also independent crimes. So in the CSC context, we can think about, and they've already been offered by defense counsel, where you have different theories based on age, of vulnerability, connection to the family. Those are clearly theories. You're claiming these are acts. Can you point to some other statute that makes independent crimes theories, not acts?
Well, actually, I think my argument, and I'm sorry if I misspoke, my argument is that there are multiple theory, that this is a multiple theory statute, not a multiple act statute. What I did was assume, for the sake of argument, that if we had a multiple act statute that we were dealing with, that one of the two exceptions that I've discussed, including the continuous course of conduct exception, would apply. And under that circumstance, there would not be a need for a jury unanimity instruction or a specific jury unanimity instruction.
Can you point to another statute that you can point to that's similar to the theory that you're presenting today?
I'm sorry, Your Honor, off the top of my head, I can't.
Okay. All right. Thank you.
One last thing that I want to talk a little bit about is just briefly about our cross appeal, if this is the appropriate time to talk about that. I want to talk about a couple of things that are not at issue in our cross appeal. I think Mr. Ferroni and I agree on a lot more than we disagree when it comes to that issue. What's not at issue is that only the providing material support sentence should run consecutive to the felony firearm sentence. Total agreement. We agree with that. Second, that the trial court has the discretion to have the gang membership felony run consecutively to the providing material support for a terroristic act. That's provided right in the gang membership statute. There's no dispute about that. And we also don't dispute that the trial court erred in not stating particularized reasons for having gang membership felony sentence and the providing material support sentence run consecutively to one another. The only dispute that we have with respect to that cross appeal is the remedy for the trial court's error. The people believe that pursuant to People versus Norfleet, which is cited in both of our briefs, all the trial court needed to do to correct this error was to subsequently, and it was at the time that I was asking the trial court to do this, state its particularized reasons for imposing consecutive sentencing. It did it with respect to one of the defendants. It didn't do it with respect to defendant Morrison. Rather, what happened here was the circuit court just ended up deleting the provision for consecutive sentencing entirely, and thereby avoided having to state its reasons for having imposed consecutive sentence. We disagree that there's actually even that second option there that the judge availed himself here in this particular case. In Norfleet 2, which is sort of the sequel of sorts, to the Norfleet decision. The trial court did indeed just do that. I don't disagree there. Delete the provision for consecutive sentencing entirely. But what happened in Norfleet too was that the prosecutor and the defense attorney stipulated to a full resentencing instead of the remedy this court sent it back for. That is the only reason the trial court avoided doing what this court had ordered to do it, to state particularized reasons for imposing a discretionary consecutive sentence. And that's exactly what was going on in Norfleet. It just instead deleted the provision for consecutive sentencing. There is no such stipulation in this case, and the trial court was bound to follow what this court had originally ordered in Norfleet 1. It erred in doing anything else. So I don't know exactly where my time is at this moment, but I would open myself up to additional questions if anybody on the panel has any questions regarding this matter.
I think we've already peppered you as much as I have.
Yeah, I think we're all set. Thank you, Mr. Palace.
Thank you very much. And we respectfully ask this court to affirm the convictions of Joseph Morrison and to remand with respect to the resentencing. Thank you very much.
Thank you.
Just briefly, there's really no reason to reach the questions presented in the cross appeal. We ask the court to vacate the convictions for the reasons stated in our appeal. But I will say this about the cross appeal. One final thought on that. There is no holding in Norfleet 1 that the remedy, the holding in Norfleet was in the case of a discretionary consecutive sentencing, the trial court has to explain its reasons, and then we, the Court of Appeals, are going to review it for proportionality. That was the holding of Norfleet. Opposing counsel is arguing there was a holding that when that happens, the trial court can't resentence, can't do this. It can only articulate reasons. That was dictum. That wasn't even a holding. So that's what I'll end with that on the cross appeal.
I think we see it oftentimes when we remand for an explanation that the trial judge decides to just do concurrent. That happens
all the time.
Probably more often than an adequate explanation is added.
Routine. Regarding the opening brief, one final thought to address. Now, I want to end with this by emphasizing that the terrorists in this case, as pled by the prosecution, was Mr. Croft and Mr. Fox. And that's important to always keep in the back of our minds because it clarifies a lot of these arguments that were made about continuous conduct and the other phrase that was used, singular plan. No, the alleged terrorists were Croft and Fox. The evidence was that there was a plan for kidnapping. When you start to get into these other arguments about murder and blowing up bridges and everything else, Croft and Fox drop out. I mean, the murder, that's Mr. Musico spouting off at a gasoline station in Jackson. Croft and Fox aren't there. There's no evidence they knew that conversation occurred. And it's Mr. Bellar spouting off in anger about the governor, making remarks that talk about drawing or something like that. And Morrison's response as well, she's going to be sued. Croft and Fox aren't even there. There's no evidence that was communicated. So always important to remember the alleged terrorists in this case were Croft and Fox. And so a lot of these internal communications, a lot of them involving Mr. Chapman, the FBI agent, you know, that's not really on point. What the issue is, what's the argument regarding Mr. Morrison? What did he do that shows he intended, knowingly lent material support to Croft and Fox to commit an act of terror? The only thing they had was kidnapping. That's why they went forward on kidnapping. Thank you.
All right, thank you. The matter is submitted. Turning now to item number 15. That's item number 370792, People of the State of Michigan versus Austin. Could we, let me just let you pause for a moment. I know we've got, I'm just gonna let, I don't know if the video camera is going to be removed from the courtroom. If so, this would be a great time. If not, it can stay. Doesn't make a difference to me. Okay, perfect. Okay, why don't you just proceed then?
Appreciate Michael Frone on behalf of Mr. Austin. Leave was granted on 3 of the 6 issues raised in the application. I think Mr. Austin had raised 10, and so on behalf of Mr. Austin, we thank the court for, for granting leave. This court asked us to brief whether the Boykins Eads issue was preserved below. Our position is that it was preserved below, albeit in a flawed manner in Mr. Austin's improper filing. And that's why I've tried to fix that on appeal by severing the OV5 issue from the proportionality issue. But our position is that it was discussed and that Boyd's and Eads actually is not a separate issue. It's just part of this challenge to proportionality that he did make. He did cite Milborn, and he did make that challenge, albeit in a way that I admit, when you go back and read that improper filing, it's not, it's not written very well. Regarding the OV5 issue, our position is the case can't be distinguished from People v. Bailey. I think that's the key case on that. And then regarding the standard 4, where there was no Ginther hearing was held, so I apologize. Regarding issue 3 and the standard 4 brief, no Ginther hearing was held, so we really just have Mr. Austin's letters. The prosecution's conceded that the first prong of Strickland was met. What I would say is that, as to prejudice, prejudice would clearly be met if this court were to find, for example, on OV5, it was scored wrong, but this is a motion for relief from judgment. The standards are much higher. And so, if it was a direct appeal, we would reverse, but because it's coming to us on a motion for relief from judgment, we're not going to. Well, and I would argue that the prejudice prong under issue 3 is met because he apparently, the way I read his improper motion is that he would have raised a challenge to OV5 in that supplemental brief. So with that, that's all I have.
Let's assume for a moment we agree with you on OV5. Send it back we vacate the sentence and we remand it for resentencing. So let's assume that happens. Would we direct the trial court to score OV5 at 0? Or instead, because we vacated the sentence, open it up again and create the possibility that father or someone else could testify to satisfy OV5?
I'll be honest, it's the latter. And that does happen. That's why I don't get that excited about OV4 and OV5 as an issue, because I know, I believe they can do that because it's a resentencing. And the case law is very clear that a resentencing is functionally the equivalent of a sentencing, and anything you can argument either party can make at a sentencing can be made at a resentencing. Yes, they could.
Okay, good. All right, thank you.
May it please the court, Michael Tesner appearing on behalf of the people, the appellee in this matter. I'm prepared to rely on my brief. I think we addressed all the issues, but I do want to address something that you asked Mr. Ferrone with regard to prejudice being met. I think it's important to recall that the sentencing occurred in 2014. The Supreme Court denied the application on this direct appeal in 2015. The cases that the defense is relying on to say that the trial court erred in scoring OV5 are all subsequent to that. At the time that the trial court scored OV5, it was appropriate. Arguably, it may be appropriate now, but the court relied on the pre-sentence report and what the victim's family had said to the probation agent that were in the pre-sentence report, and also the demeanor of the testimony from the father and his statements. And I would argue that that it was not error to score OV5 in this matter. And it wouldn't have mattered if it was on direct appeal, because the case law they're relying on now, and that the defendant relied on in his 6500, was non-existent at the time.
But OV5, in terms of the language of OV5, has remained the same. You're pointing out that the case law has changed.
Correct.
Okay.
And if the court has any other questions, I'd be prepared to answer.
We're all set. Thank you.
Thank you very much.
doesn't state, I don't disagree with opposing counsel about the case law, but I respectfully disagree that we know that OV5 was decided correctly at the time and that we know it would have been affirmed on appeal. We don't know that. If Mr. Austin had appealed instead of People v. I think it was Bailey, it could have been People v. Austin. OV5 is misscored, read the same way. So I respect, that's the only part I would push back on a little bit on their argument. Other than that, no, thank you.
All right, thank you. All right, item number 15 is submitted. Turning to item number 16, People of the State of Michigan versus Eberline, 371674.
Michael Frone on behalf of Mr. Eberline. Regarding issue 1, I'm going to just admit, but I think I should have raised that as a change in law argument. I think they have a point about People v. Duenas. I looked at it. I may not agree with Duenas, but when I went back and read their brief, I actually think I can't distinguish this case from Duenas, and I think that I wish I'd raised that as a change in law argument. I think they're probably correct on issue 1. It doesn't, Mr. Eberline was still looking at a 25-year minimum, and the effect of it, the impact of issue 1 would be one less conviction if he were to prevail on it. But I think that's something that would have to be argued to the Michigan Supreme Court. This court does have to follow People v. Duenas. I can see that. Issue 2 would be his main issue. I don't have anything to add to the brief. We went through the Watkins factors. I'm not entirely sure why it was argued as MRE 404B below, other than that's how the prosecution filed a notice under MRE 404B. And so everyone sort of went forward and made those arguments. But if this court concludes that section 27A applies, there's no reason to even analyze the issue under 404B. There's case law that makes that clear. But for that reason, we argued it under both. But if 27A applies, and it does appear that the correct analysis is under 27A, then the court doesn't have to really even address 404B. Regarding the sentencing issue, our position is that, well, there was a 25-year mandatory minimum. The prosecution, I don't believe they asked for departure. The trial judge did depart 5 years, not an insignificant amount of time at all. I think, and if we look, I don't see an explanation for it. The court gave its reasons for the CSC second sentencing, and then, in post-sentence, I don't see an explanation we can look at, that this court could look at and analyze whether that was sufficient to add on the other 5 years. So what would the remedy be? It seems this is kind of a continuing theme in a number of our cases. I think the remedy would be, Mr. Eberline's case would be to send it back for a resentencing, not to send it back for an articulation of reasons. The court could do that, but do this long enough that I sometimes will come across things, things were done in the 90s and the first early part of this century. And but this is 2026. We have to, for a long time, that is what this court did do. It would send it back for articulation of more reasons for the court to explain why it went 5 years above the mandatory minimum and outside the guidelines range. But I think if we look at more recent case law, and I would draw the court's attention to People v. Mason. There's no number on it yet, but it's docket number 367687 from this court. This court does state in Mason, if the Court of Appeals determines that the trial court has abused its discretion in applying the principle of proportionality by failing to provide adequate reasons, because that is what issue 3 is about. It's not, I don't think we're really challenging the proportionality. We're saying before we get to that, there's no reasons given for why the court did what it did. By failing to provide adequate reasons for the extent of the departure sentence imposed, it must remand to the trial court for resentencing. And it cites cases from our Michigan Supreme Court, I believe Stenos. I think that's the correct remedy. A lot of times when you send it back for articulation of more reasons, it just ends up coming back to this court on the same issue. I think the correct, in addition, I'll end with this, Judge Bell is retired. And so we would be sending it back to her successor judge asking that judge who didn't preside at the trial, didn't preside at the sentencing, to come up with reasons to explain a decision Judge Bell made, which they may not even agree with. They may not have gone, the extra 5 years above. So for those reasons, if the court reaches issue 3, we would ask respectfully that they consider sending the case back for a resentencing rather than, the court to the substitute judge to explain reasons for the departure. Unless the court has questions.
I don't see any. Thank you.
May it please the court, Katie Jory on behalf of the people. Your Honors, I would also mostly rely upon my brief and open myself up to this panel's questions if there are any. I just do want to quickly note that I believe I actually agree with brother counsel here regarding if this court believes that Judge Bell did not articulate enough on the record the reasons for her departure because she has retired from the bench and there is a successor judge, it would probably be most appropriate to have a resentencing instead of trying to have a successor judge articulate further reasons that he didn't put on the record in the first place.
All this agreement among counsel is a little
Subtly.
It's disconcerting, isn't
It
it?
is.
I don't think I've ever found myself in this position before.
I think you both did that in the course of this argument, right?
Your lead issue. Yeah.
Anyways, Your Honors, I believe I sufficiently addressed these issues in my brief. I would rely upon it, ask this court to affirm, open myself to any questions of the panel.
Thank you.
Thank you, Your Honors.
Good. Okay, thank you. All right, the matter is submitted. Turning now to item number 17, People of the State of Michigan versus Grant, 371830.
Good morning, Your Honors. Again, Michael Ferrone on behalf of Mr. Grant. I think this is an interesting appeal because regarding the 27B issue 1, the trial judge had reluctantly, that's how I read the record, allowed the prosecution to call. Then, after hearing her testimony,
No, she was a witness, but I don't know that we want to use her name.
I apologize. She's an adult, but I agree. I agree. I apologize to Miss.
I think it was the ex-girlfriend.
It was.
Yeah.
It was. She was adult at the time, adult at trial, but I understand. I agree. I apologize. After hearing her testimony, the trial judge regretted doing so and considered sua sponte, directing the jury to disregard it on grounds it was too dissimilar to the charges or otherwise violated MRE 403. In fact, the trial judge said he was taken aback by the emotion of her testimony. And
Mr. Ferrone, you've done this work for a while. Have you ever seen where a witness kind of breaks from testimony and goes and kind of verbally goes after the defendant in this way with this kind of emotion?
Rarely, I can't say no because I have a case, pending in front of this court, which is
But it's rare.
very much rarely. And really, I remember that case because, in this case, because it's very rare.
I've never seen it before, and it seemed that the trial judge hadn't seen anything like this before because the trial judge both apologized to the witness as she was leaving, and then during discussion with the lawyers, essentially said, the jury probably didn't even hear me because she was crying and she was so emotional.
Mhm.
I've just never seen that.
In fact, this case, I'd have to, like this, never seen it before. The other case I'm thinking about, I don't want to say too much about it, it's coming up, was anger. It was a witness who went after the defendant, angry remarks. This with this emotion, no, it's very unusual. Wasn't, even reading the transcript. And the trial judge makes it very clear. And I think that it is to the trial judge's credit that he thought about sua sponte, not declaring a mistrial, but
I understand what you're saying. For me, there's two parts of this. The first part is, the emotional impact. And a trial judge has to make a decision before trial about whether this witness is going to testify or not. That witness is not in front of them. It's represented what that witness is going to say. How that plays out in the drama inside of a courtroom is an unknown. So there's the emotional impact. It's hard. Not every 404B CSC victim testifies the same. This was admittedly different than whatever the average means. And a trial judge, it's hard to fault them in assessing that in the sterile environment of a 404B motion 3 months before trial. Having said that, that doesn't answer the other question is, should this witness have been on the stand in the first place?
Correct. That's a different, you're correct. You're absolutely correct because the premises of that are very different. There's two other parts to it that I would say go beyond the emotion. Once it happened, should the trial judge maybe have done what he was considered doing and sua sponte and, instruct the jury? There's that. But even back in time, should the testimony have been allowed to begin with, they were very dissimilar offenses. I mean, to say that the 27B witness, she describes a very violent assault. I don't want to go into the details of it, but if you read it, force, violence. The case before the jury wasn't really like
In their mid-20s.
right, older.
They had had a relationship for a number of years. They had a kid together. Where this situation with the complainant here was a teenage boy. And so the Venn diagrams of factual circumstances don't overlap a lot, it seems. Other than, I think you could say there was a domestic relationship to both.
Right.
And then there was, what I also found interesting in the record was right after this witness gave her testimony, there was a conversation about whether a trooper or a police officer of some kind was going to give testimony based on his interview with the defendant 2.5 decades before about what had happened with this one witness. And that was disallowed. But it seems like a lot of the testimony, a lot of the rationale of why the trooper was disallowed would have applied equally to the witness. Can you address that as well?
Probably not. I can't recall the reasoning of that other than I can't. I'm going to just admit.
No, that's fine.
I mean,
No, that's
I don't
fine.
want to
I mean,
make.
the record says what it says.
Yeah.
So
I mean,
let's put it this
I'm
way.
going to rely.
Let's put it this way. Assume for purposes of this question that the rationale of why the trial court did not allow the trooper to testify at least was somewhat similar to what you're arguing here. Does that give further weight to your argument that the witness's testimony should have at least been struck?
Absolutely. And I apologize for not being able to, I'm just going to fall back on it 5 cases. I missed that part of it, the troopers, why that was struck, but definitely, if the trial judge reasoned, and I vaguely remember it, that the trooper cannot testify because difference in age, adult child, relationship, all these factors, well, certainly they would apply to whether the testimony should have come in to begin with. Under 27B, that's something that really even back under 404B, that's something the court would be looking at. I mean, it goes to relevance, it goes to
How would you respond to harmless error?
simply that, like many of these cases, it was a he said scenario. I mean, I hate to use that expression. It's kind of cliched, but I'm looking for their initials. They usually ZC. ZC did come forward in this matter for some years. I hope I'm remembering that correctly. I mean, there was some delay. There was no, I mean, there can be, in this type of case, a number of things can come in that would corroborate ZC. It's just often the case that there isn't. That's just the nature of the offense. I accept that and I understand that. But when we get to the point of looking at harmless error, prejudice, the impact of this testimony, it's just a feature of this case that it came down to the testimony of ZC.
So I do have a question on that. You have the trial court who properly instructed the jury that the defendant was not on trial for whether for CSC related to the witness or to the ex-girlfriend. So you have, and you have loads of case law that said we presume that the jury follows the trial judge's instructions. Do you have any case where you have something like an extreme emotional outburst during witness testimony that somehow overrides that presumption that the jury follows the trial judge's instructions?
I don't. I think it goes back to what we were talking about a moment ago, that this was unusual. I looked. If it's there, I didn't find it. In fact, I've had occasion to look for that case, I think in 2 appeals.
But that the words alone would justify a mistrial, notwithstanding instructions to ignore what happened. Well, it would be an example, Andy failed the polygraph.
Right.
Right. I think the case law is pretty clear.
Right.
In that situation, you can't say,
Right.
Unring that bell.
Certainly. Nothing on point with factually with the emotion and all that, but that something can be said in court, which requires reversal, in which the appellate court did reverse, even though there was an instruction that, you could say went the other direction and would have told it. There are many cases like that. That's not that unusual. Of course, we trust juries to follow their instructions. The jury was instructed to not find Mr. Grant guilty because of what, Ms. Cotton. I did it again. I apologize.
Sorry, well,
I'm gonna, because fortunately it's a common name. Because of what the other witness said, but there are many cases, that would be one of them, involving a polygraph, in which the jury instruction simply isn't sufficient, isn't enough to disregard the error. So there's that. I'm gonna have to make a note of to remember, even if it's an adult, to come in and use initials. I adjusted to the minors, but I think I haven't quite. But I'm gonna, believe me, lesson learned. From now on, when I come in,
Mr. Ferone, you're an excellent attorney. You don't have to apologize.
I always have. I never have, when it's a minor, I never have their name in my notes. I always have the initials, and that
I'm
will
not
happen.
sure that each panel treats it the same, but this
Right.
one
Well,
does.
I'm in the future. I will. Thank you.
All right, thank you.
Good morning. May it please the court, Assistant Attorney General Daniel P. Kelly on behalf of the people. This appeal presents 2 evidentiary questions, both reviewed for abuse of discretion, and the record shows the trial court exercised exceptional care. Each ruling reflects exactly what the legislature intended when it enacted MCL 768.27B and 27C, broader admissibility in cases involving sexual and domestic violence, with the traditional safeguards still preserved through Michigan Rule of Evidence 403. Starting with issue 1, the admission of the 1999 assault under 27B, the statutory exception for the older acts unquestionably applies. Once that threshold is met, the remoteness is not necessarily a bar. It simply becomes one of several 403 factors. And similarities are meaningful in this case. In both assaults, the defendant preyed on a member of his own household, isolated the complainant, used force, pinned the complainant down, and ignored their pleas to stop, and used the privacy of his bedroom to commit the sexual violence. This is exactly the pattern the legislature wanted juries to see when evaluating the likelihood of the charged conduct. And the judge To his credit, trial judge did exactly what we want trial judges to do. He evaluated the motion pre-trial, heard DC's testimony, paused the trial to reconsider sua sponte, applied 403 a second time, spoke to the parties, and then reaffirmed his ruling. That deliberation places this decision firmly within the range of principled outcomes.
So, I think Judge Cameron brought this out well during opposing counsel's argument that maybe the trial judge did not abuse his discretion when allowing this, allowing it in, saying it could be used 3 months before trial or whatever. What about the question of whether it should have been struck after the fact, given the emotional outburst, given how clearly impactful it was? I've never seen a trial court have to apologize to a witness for the emotional toll that it took. And the fact that this was the last witness the jury heard before they deliberated for 38 minutes on these 9 counts.
Well, Your Honor, so to answer your question, it's still 403 is the issue there. Still have to make sure that it is unfairly prejudicial. And the showing of emotion by a human being who was victimized by this particular defendant, that, of course, would be prejudicial to anyone. I mean, that's why you want to admit any evidence, right? If you want to admit evidence against a defendant that prejudices them. But this is not unfairly so. It falls well within the statute, and just because somebody's emotional about how things happen to them didn't make it an unfair prejudice under the 403 balancing test.
You're asserting that it's not unfair. Do you have any explanation of why it's not unfair? And especially given the fact that this defendant was not on trial for this event that happened 2.5 decades before?
Well, Your Honor, I would argue that it's permissible under the statute, first of all, 2027B to allow it to come in. And then doing the balancing test, I would still say, I'm asserting it. I don't have a case I can point to where there was a similar circumstance where it was determined that itself was not overly prejudicial or unfairly prejudicial. But I do believe by giving the limiting instruction, the trial court did in fact, alleviate any potential unfair prejudice that did.
Is there any level of anger or emotion that in your mind would override a trial court's proper instruction? Or is it literally the witness can show a level of anger or emotion and the trial properly instructs the jury? Good enough.
I would go with the latter, Your Honor, good enough. I really do believe that. And that's because witnesses are human. They feel emotions. And we can't predict what those emotions will be or how they will actually appear on that individual person.
What about the fact that the trial court did not allow the trooper to testify, where I would assume at least much of what the trooper would have said would have been corroborative of what the ex-girlfriend said here?
And I have to say, I can't remember specifically the reasons the court gave for not allowing the trooper to testify. However, I think one of the reasons that maybe does not necessarily cut against my position is that it may have been unnecessarily duplicative under 403. Or
Let's assume it was not
cumulative.
I've read the transcript. It was not that.
So I'm sorry, could you repeat what's the question then, Your Honor, about why? Is that your question?
Yeah, I mean, if the trial court doesn't allow the trooper to testify, and it wasn't because it was going to be unnecessarily, or it was going to be unnecessarily duplicative, does that weigh in favor of at least having struck the ex-girlfriend's testimony?
I don't know that it necessarily weighs in favor of having necessarily should have struck the ex-girlfriend's testimony. What it does weigh in favor, though, is of a benefit to the defendant. It was a limitation, prevented additional what could be considered prejudicial evidence from coming in against him. So I would say it's a benefit to the defendant, although I don't know that it would really necessitate striking or giving a stronger instruction to the jury regarding the ex-girlfriend. I do believe the trial court could have permissively allowed the trooper to testify as well, because it would have corroborated that story and made it more or less likely that Mr. Grant was capable of committing the type of crime that he was charged with, and the very reason for the statute 27B exists. And then turning now to issue number 2, I don't know that I want to spend too much time on this, but I do believe, based on our briefing, that this fell squarely within the statute. The disclosure, though, that did occur wasn't years later in this case. It was somewhere between 1.5 months and 3 months later, depending on when the school year ended. Now, our ZC did have some developmental disabilities, so nailing down a timeline was somewhat challenging. And that really did, I think, help a little bit by having the deputy testify, because he was able to fill in some of those gaps from the disclosure. And there's absolutely an indication that the statement was reliably made under the forensic interviewing protocol. So pending the court's questions, though, I don't have anything else to add to that issue.
No questions. Thank you.
Unless the court has any questions for me,
I don't see it.
appreciate it. Always a pleasure appearing in
Yeah,
front of you.
thank you. Thank you very much. The matter is submitted. Turning now to item number 18. People of the State of Michigan versus McKinney. That's item number 371378.
Mr. Ferone, you're leaving us?
Hopefully you don't have too many parking tickets.
Oh, I'll probably be back.
I had 3 in a row last month, so I don't know how I did 4 in a row. Fall over.
I don't know how you keep them straight.
That's really tough. It was way tougher than I thought it was going to be. It was a first for me. Is there someone dialing in or?
Number 18, I don't have anyone here remotely on number 18. I think it's just you.
Oh, okay.
So-
All right.
Your appearance in the record, and I think we can move forward.
All right. Thank you. Susan Walsh on behalf of defendant appellant Cecil McKinney. I think this is a pretty interesting issue of first impression for this court. I know the first issue's been thoroughly briefed. Well, all the issues have been. I would just emphasize that the prosecutor didn't address the People versus Perry decision, which held that the prisoner in possession statute is not a strict liability statute. And I would argue that this MDOC directive.
Wasn't Perry, the momentary possession, part of a self-defense theory?
Correct.
And is there any self-defense argument here?
I would argue that the case is different. I would concede that the case is different than Perry, but that this MDOC directive, and I wish that they would record these in-chamber conversations, because I have no way of knowing the complete argument made by defense counsel that there needed to be a special jury instruction under these circumstances because of this MDOC directive. And because of that, the need for a self-defense defense, or all these cases that were relied upon by the prosecutor about CCW, felon in possession and felony firearm, they really don't, they're distinguishable because of this MDOC directive. And I believe that because of that directive, there did need to be the momentary innocent possession jury instruction. And I believe that it was outcome determinative, especially, particularly in this case, because the video didn't have any audio. So, it came down to the credibility of these parties, and had the jury heard that, under this directive, there could be momentary innocent possession of that lock in the sock, that really could have swayed their credibility determinations. And also, because of the 2-hour limit, like, he ended up getting 3 extra years in prison. So imagine the pressure on the inmate that they've got 2 hours to get in touch with somebody. This is a prison. Who knows what is going on? And I believe therefore that this was a very important issue and a very important instruction to get to the jury in order for there to be a fair trial. And then as far as the hearing aids, again, a very unique issue. The hearing aids didn't work. The trial court should have had working hearing aids and they did not. And so everything has to be moved all around. Mr. McKinney has to write notes. He didn't hear the jury selection. I believe that this greatly prejudiced him. I believe that it was a structural error and that new trials should be granted on that issue. At the very least, it was prejudicial to him, especially, I think, trying to communicate with his attorney. So unless the court has any other questions, I think that everything's in the briefs. Just wanted to highlight those things.
We're all set. Thank you.
Okay, thank you. I will stay right here and move on to
Well, let me move on.
Yes, yes. Go ahead.
Item number 18 is submitted. Turning to item number 19, People of the State of Michigan versus Sykes, 367133.
Okay, all right. Oh, good morning. All
Could you
right.
put your appearance on the record again?
Okay, Susan Walsh on behalf of defendant Sarah Sykes. We have another case where I believe that the decisions in Stovall, Parks, Taylor, Sarnecki should be extended to apply to this case where when my client was 20 years old, she was involved in a tragic killing where she was not the shooter, but she was given a life sentence with the possibility of parole. And she has already served close to 20 years in prison.
So we're an error correcting court. You want us to extend the law or let the Supremes do it as they've been doing?
Well, I think that the Eads and the Eccles panels extended the cases. And so I think
Isn't one of those on review now?
yeah, they're both on review.
I mean, it almost seems like our voices would be, it's going up. We don't know where this is going to end. I think anybody who read the first case, I think it was Parks, would suggest it's going to end at 25. But I don't know, maybe some new article is going to come out in a scientific journal and say it's 30, 40. I mean, it's impossible to know. And so I think my longer drawn out soliloquy based on Judge Boonstra's point is, how do we, what kind of judicial standards do we have to make a call here when it's based on scientific journals?
Well, I understand.
We don't even have factual findings made by a trial court through the typical process of direct and cross-examination of experts to review. We just have journals.
Well, I think they're peer reviewed and I think they're not just people, writing down whatever and putting it out into the social milieu.
I'm not disparaging the academic work on it. I am suggesting that we're not the academy. We're a court. And we typically, as an appellate court, we look at factual findings made by a trial court. After a Daubert hearing and after evidentiary hearings and after cross-examinations and after dueling experts, we just don't have any of that. So how do we know whether it's 20, 23, 25, 27, 45,
18.
18? That'd be novel.
Yes.
Well, I think you could go back to 2012 when Miller was decided and they determined, the United States Supreme Court determined that there were cognitive limitations in juveniles and that therefore I think, was that the death penalty or life without parole? There's so many cases and I try to remember which one applies to which. I have them written down. And I think that, I think there is, accepted scientific studies that, the brain becomes completely matured at 25. And I have 3 children, so maybe I can throw my 2 cents worth in there too.
I'd like to tackle this from a different direction. Everything's on the front end about what brain maturity and all that. And as my colleagues have already identified, it's probably for another court to decide, not us. But the other side of things is, what does parolable life mean?
That,
And let me, I'm working out on a question. If you asked a county prosecutor 20 years ago about if you had someone who had sexually assaulted a child and they were sentenced to 20 to 40 years, that prosecutor would probably tell that victim's family that historically the parole board does not grant parole to these people. They tend to hit their maximum. So that 20-year minimum, you should look more toward an exit date closer to 40 than 20. That world has changed. The parole board is very different today than it was 20 years ago. So the notion of parolable life means something, I think, something different today than it did 20 years ago. Someone sentenced to parolable life 20 years ago might serve 50, 60, might die in prison. And plenty have. The parole board composition has changed and people are released earlier. And I don't know what that number is today as compared to what it was 20 years ago, but your client has served how many years in prison?
close to 20 years.
Close to 20 years. Even if, rather than looking at the science, what does parolable life in terms of an exit date mean? Because if parolable life means 25 years, right? If the expected exit date for your client is 25 years, 5 years more than today, why do we have to get bogged down in the science and on the front end when parolable life only means 25 years and it can't possibly be, given the nature of the offense, cruel or unusual?
Well, I think that historically, the cases where life with the possibility of parole, they do often end up to be life sentences.
But to reiterate what Judge Cameron said, we're past history. Historically, we treated 18-year-olds as adults. We're past that. We no longer do that. So I don't know that it's very compelling to say, well, over the last few decades or historically this. Judge Cameron has indicated we're in a brand new world. And in today's life without possibility or life with possibility of parole, when is your client eligible for parole?
After 15 years and then every 5 years thereafter.
So she's already gone through the parole process once.
Right.
And presumably she's going to be up, or if she's been in 20, she's up soon. And then maybe in 25, so every 5 years.
Right.
Okay. And if her crime was so not the worst murder we've ever seen, her involvement, like you said, she wasn't a shooter or anything, wouldn't she have a better opportunity of possibility of getting parole than if we sent it back and she just got 40 years?
Well, I think that the problem is that she only comes up for parole every 5 years, and that's a different standard. And so I think that that she should be given an indeterminate sentence so that she can be dealt with in the same way as, all other inmates that have indeterminate
What if she went back
sentences.
and she got resentenced and the sentencing judge said 40 to 60 is the appropriate?
Well, then
Will she be in a worse
litigating that.
situation because she wouldn't?
Well, maybe not, and that would definitely be appealed. And I would strenuously argue that that would be a harsh and unreasonable sentence.
Why? Why would it be harsh and unreasonable or cruel or unusual?
Well, it would be a disproportionate sentence, the 40 to 60, because of the mitigating factors of her youth and her horrible childhood and upbringing, where she was never, the Taylor Sarnecki opinion, they talk about the impulsiveness, the recklessness, the risk-taking of of juveniles, and then Parks extended that to the 19 and 20-year-olds. And so to give her a 40 to 60-year sentence, I would not take any of that into consideration and would thereby be an unreasonable and disproportionate sentence.
Well, someone who's 20, who commits a crime like your defendant, has a background like your defendant, what should their maximum time in prison be?
Well, I think the maximum sentence is largely impacted by the reformation and rehabilitation of the defendant while incarcerated. So that would be up in the air. I think that if the inmate were to be rehabilitated, model inmate, showing all signs of being able to become a member of society, then the probably should be released at their minimum sentence and put on parole. But if that, if the defendant went into a gang and had 20
So is your argument,
misconducts,
is your
no.
argument that we should find that life with the possibility of parole for a 20-year-old who commits second-degree murder is cruel? It's not unusual. It's cruel. You would have to win on cruel, and then therefore she should get resentenced, and it should be the resentencing should be for time served.
Well, I'm sure that would be the argument.
I'm asking you, do you believe that that would be the proportionate sentence in this case?
Well, I think that the average sentence for second-degree murder as of recently, I think in the 2020s, I think it was between like 25 years and 27 years.
Okay.
And so I would say that, and Ms. Sykes is extremely remorseful, and she doesn't ever think that she doesn't owe a debt to society. But I think the low end of her guidelines were about a 22-year sentence. So, something in the mid to low 20s, maybe I would say. But I'm not a trial judge, so I don't have a lot of experience with that. So I think I've made my main points, and I would just contend that under Taylor, Sarnecki, and other cases we've discussed, that remand for resentencing is appropriate. Thank you.
Thank you, Your Honors, and may it please the court. My name is Gabrielle Ragland. I'm an assistant prosecuting attorney with Washtenaw County, and I represent the people in this matter. As this panel has already pointed out, this is an error court, a court of correction of error. The Michigan Supreme Court is probably, if there was to be an extension of the case law, probably the more proper forum in that case. Regardless, the Michigan Supreme Court, Ms. Sykes fails on 2 points based on the case law. 1, she is above the age of 19. We've set that. And 2, she has a parolable life sentence. Now, what that means isn't necessarily that she will get parole. It just means that she has a reasonable opportunity to make parole. As this panel has just indicated, she has now been up for parole twice, or will soon be up for parole twice. If she were to be resentenced to the minimum of 25 to 40 years, there's no guarantee that she would be out in that 25 years anyway, possibly rendering this whole issue moot. moot rather. But something that the people want to emphasize is the extreme gravity of this offense. Unfortunately, this event did not just, is not a, I guess I would say a typical second degree murder. Two children died as a result of Miss Walsh's actions, regardless of whether she actually pulled the trigger. She did drive the triggermen there. She drove a group of people after having an incident. The person she shot at was a boyfriend of hers, where she was upset, and it was the second time she had gone to that place within the day. So I believe that limiting this and saying that this is a typical second degree murder case, the only reason I believe she received a second degree murder conviction is because she had a degree hearing and she pled. Regardless, that's not here nor there. My brief is extremely, I know that the panel is prepared. The panel has already asked some questions of Ms. Walsh. Do you have any questions for me directly? Anything that I could add on to?
You know,
Okay, making this easy for me. Thank you.
Thank you. Walsh? Can you remind me, did you say 20 years she's been in? How many years?
Yeah, right around there.
And she's
I
up for
think I'm-
parole, but within the next 5 years, within 2 or 3 years, fair to say?
Or maybe less.
Or maybe
Yeah, yeah.
less, 1 to 2, 1 to 3.
Right.
I guess maybe maybe a different way to put it is, to your knowledge, has she been recently denied parole
No.
within
not
like
to
the
my-
last year? So presumably she should be up in the process of parole potential right now. If she hasn't been denied recently, then you would presume that she would still have that opportunity, that window open.
And the reason,
I believe she's completed 7, so she should be up next year.
okay, so the reason why I asked that is that when we're looking at whether it's cruel, the sentence is cruel, it seems to me that we're looking at in terms of the outer bookend of what that means, cruel. I don't think we should be looking at this, that the average, whatever that means, the average parolable life sentence is a 60-year sentence, and to impose a 60-year sentence on this individual is cruel. Instead, I think, and this is your opportunity to respond to how I'm thinking. We should be looking at this as, is it cruel to have your client have been in prison for 20 years for this murder and eligible for parole next year? Because next year she might get parole. Maybe, maybe not. It seems to me, fair or not, you would have a stronger case for it being a cruel sentence if your client had been in prison for 60 years, not 20. Because she could get parole next year. That's the bookend I'm focusing on, rather than the brain science, which is not for this court, in my judgment, to look at. You're saying this is cruel, and all we can look at here is a 20-year sentence plus a parole hearing next year.
Well,
So
I think.
tell me why.
Okay.
I sense you think I might be wrong, or so
Yeah.
explain why.
Well, in Taylor Sarnecki, the a court applied the Bullock factors and stated that a parolable life sentence is the most severe penalty that can be imposed for second-degree murder. And I think that that is because of the reality that that parole hearing coming up historically is in name only, that she will not get parole. And she probably never will get parole.
And that's where I'm
Under
struck.
states.
That's what
Right.
I'm hung up on, is because the parole board, the members of the parole board come and go. And the attitudes of the parole board are very different this decade than it was 2 decades ago. And the point I'm making is that you're making it's a cruel, unconstitutionally cruel sentence to impose a 20-year, because that's all that's what she's been in for, 20 years plus a parole date coming up within the next year or so. And I don't know that we can say, well, it's the most severe, therefore it means 60 years, because it may not.
Well, looking at that, the Michigan Supreme Court has said it's the most severe penalty. And
That wasn't a holding. They didn't hold that. And so, you know, I think Judge Cameron brings up a very interesting empirical question. The brain science is an empirical question. And so if courts can look at brain science as an empirical question, like they did in Parks and cases thereafter, I don't see why we're precluded from therefore looking at the empirical question of whether today, June 2026, this parole board is different and more open to parole than in years past. Is there, do you see any reason why the first empirical question is appropriate for courts to look at, but somehow that second empirical question is off limits?
Well, I do think so because the human brain is the human brain from now and evermore, as opposed, and so the
Charles
empirical,
Darwin would
the
disagree with
research,
you on that.
well, the research into the juvenile brains and abilities, sure, it will change over time, but very slowly, I believe. Whereas to do research on a parole board, I don't even know how you could. People are changing all the time, rules are changing all the time. And I think that that's what makes the sentence cruel, is that there's no good standard for her moving forward, as there would be with the indeterminate sentence. I mean, that's why people would rather have, 25 to 60 or whatever the case may be than have this nebulous parolable life sentence that in most cases people never get out of prison.
Seems like you want us to treat a parolable offense as if it's not parolable just because you think the parole board won't grant parole. How do we know that?
Well, from history, from what's happened in the past. And perhaps, the whole system needs to be revamped due to these decisions.
Good question
But-
for the legislature.
Yeah.
Right,
Yeah.
but
I
that's
mean, federal
still,
system doesn't have a parole board.
that's
It's
still,
determinate sentences.
right, that still leaves Ms. Sykes with a cruel sentence that will, if history repeats itself, will result in her spending the rest of her life in prison. And for an impulsive act, she was an impulsive person with a teenage mentality wanting to retaliate against a boyfriend. She had absolutely no intention of anyone ever getting killed, and she begged these people not to shoot their guns. So under these circumstances, I strenuously believe that it is a cruel sentence and she should be resentenced.
Thank you. Interesting. Thank you very much. The matter is submitted. Turning now to item number 20, People of the State of Michigan versus Pool, 374059. Looks like we do have one or more council remote.
I pulled him in, but it's slow going, so hopefully he shows up here shortly.
All right, thank you.
Okay, am I with you now? There we go.
All right, we can see and hear you.
Okay, William F. Branch, attorney for the appellant.
Go right ahead.
Very good. Am I alone?
No, council's in the,
Okay.
go right ahead. You're the appellant, so go right ahead.
Okay, judges, you first look at this case and it looks like, well, here we go again. Another he said, she said, CSC conviction, evidence being a couple of years old. But there is one different element to this case, and it's also I'm going to bring it in response to something that the prosecutor said in their brief. And of course, the element that's a little bit different is here we actually have the defense attorney at the trial developing a theory of false memory. And she does it through both the expert witnesses of the prosecution and her own witness, Kimberly Fenn, a professor at MSU. And Judge Fenn, or Professor Fenn in particular, explains the factors that can lead to false memory and even traumatic memory, which and these factors can be from high stress or emotion. She explains that memory can be distorted by retelling, other people asking about it, or even just thinking about the event. And she clarifies that the best way to determine if memory is accurate is to find objective verification, which of course we don't have in this case. Now, my point is the prosecutor says in their brief that, okay, you have this evidence of false memory, but there is no indication that the witnesses in this case were subjected to false memory or those factors. But there is, and that evidence is really typically going to be the only evidence there can be, and that is the testimony of the witnesses themselves. And here, the complaining witness, MJ, admits her memory is poor, not accurate. There's one interesting point in the transcript where the prosecution seems to expect her to tell more. He asked her what else they can tell her, if she can tell anything more, and she says no, she doesn't remember anything more. She can't recount any other time that the defendant touched her. MJ, one of the other witnesses, doesn't remember what she said in the forensic interview. Not surprisingly, what she says in the trial doesn't match what she said in the forensic interview. Another one of the other acts evidence witnesses, AM, testified clearly that she was 13 years old when the event occurred, and then later concedes that, in fact, she was 15. Now, you can say, well, she's a child, she's going to disremember things like that, but you would think that proceedings before in her own case, you would think she would have remembered that. DP, another other acts witness, couldn't recall what she said at the forensic interview, that her mom was in bed with herself and her dad. That would seem to be an important factor. So both MJ and DP had reason to fabricate. The defendant wouldn't call, excuse me, I'm saying MJ, I think that's correct. When you call MJ by her preferred name, Wyatt, she was upset about that. Both the girls were upset about Mr. Poole's drinking and using drugs. They didn't like that he wanted to leave the family. And these are just the type of factors that Professor Fenn tells us could lead to false memory, which the tellers absolutely believe are true. Now, of course, we have all the law telling us that at this point in the proceedings, great deference is to be given to the findings of the jury and their determination of credibility. And I would just again cite this language in people, which we have in our brief, that says the fact that some evidence is introduced does not necessarily mean that the evidence is sufficient to raise a jury issue. In quantitative terms, the fact that a piece of evidence has some tendency to make the existence of a fact more probable or less probable does not necessarily mean that the evidence would justify a reasonable juror in reasonably concluding the existence of that fact beyond a reasonable doubt. So, and I bring all this up, Judge, in response to the idea that there's no evidence to support the idea that the false memory came into play. I think there was such evidence that a reasonable juror would have concluded that the burden of proof had not been overcome beyond a reasonable doubt.
All right. Any questions? No questions. All right. Counsel?
Good morning again. Assistant Attorney General Daniel P. Kelly on behalf of the people. This case comes to this court in a posture that is very familiar in criminal appeals. The defendant does not dispute the governing law, does not challenge any legal ruling by the court. He simply disagrees with the jury's credibility determination. And under the longstanding Michigan and federal precedent, that is not a basis for reversal. Now, it's far within the province of the jury to make determination regarding credibility. The jury heard testimony from MJ, who provided direct testimony on all the elements of both CSC 1 and CSC 2 as charged. And the jury also within their province to give appropriate weight to evidence presented at trial, including any potential expert testimony. The jury heard the expert testimony and decided not to credit it. The jury did, and good choice not to, because there was no evidence in the record of false memory. Now, that was the theory of the defense, but it was not something that a rational juror could find. So based on the evidence in the light most favorable to the prosecution, a rational juror could have found these charges as charged and convicted, and therefore this evidence was sufficient and this court should affirm.
The only question I have is, I was a little unclear from the record. Was the oldest child a stepchild and the younger child a biological child, or were they both step?
Your Honor, I'm going to qualify my answer. I did not draft the brief, so I'm not as familiar with.
That's why it's great to be appellate lawyer. You know, you can just.
But I do believe the older child was a stepchild, whereas the younger child was a biological child.
Okay.
That's my recollection, but again, I can't say that with any certainty.
Okay, appreciate it. Thank you.
All right, thank you very much. Any rebuttal, and can you clarify that last point in terms of biological versus step?
I believe the prosecutor is correct on that, Judge. I'm looking through my notes right now to see if I can make a determination. I believe the prosecutor is correct on that. Oh, well, let's see. Now here I have DP was Kirk's, the defendant's biological daughter. So DP is a biological daughter. She was 14 years old at the time of trial.
All right, thank you.
And her old, KP and M are therefore stepchildren to Kirk. There we go.
All right.
So
Anything?
DP is biological. The other two are stepchildren.
All right. Anything further?
No.
Okay. All right. Thank you both very much. That matter is submitted.
Thank you.
You're welcome. Thank you. You're welcome. Turning to item number 21, People State of Michigan versus Davis, 373926. All right. Do we have Mr. Simon here? I don't see him on remote. Remote. Thank you.
There he is.
Yeah.
And his cardinal was.
All right.
Good morning, and may it please the court, Jonathan Simon on behalf of Mr. Davis. I really have nothing more to add than what is stated in my brief. It's our position that there was consensual admission to the premises, and that as a result, the felony murder conviction should be vacated. The matter should be reduced to second-degree murder and remanded for resentencing.
Thank you. Counsel, go ahead.
May it please the court. Good morning, almost good afternoon. Elizabeth Allen.
That left.
I'll be that quick. Elizabeth Allen, Ingham County Prosecutor's Office on behalf of the plaintiff appellee. I agree with Mr. Simon that the issue is fairly narrow in terms of what has been raised on appeal and thoroughly briefed. It's based on the facts that were brought to the jury and the evidence, including the video. We believe there's direct and circumstantial evidence sufficient to convict the defendant of first-degree home invasion and then also the felony murder that went along with it. So unless there's any questions from the panel, I'd ask this court to affirm. Thank you.
Thank you. All right, Mr. Simon, any rebuttal?
Briefly,
All right, you froze. That was very brief. All right, if you don't unfreeze soon, I'm going to move on. All right, the matter is submitted. Turning now to item number 22, People of the State of Michigan versus Lambert. That's item number 373599.
Mr. Herskovic will be there momentarily.
Thank you.
Good morning or good afternoon at this point, Your Honors.
Good afternoon.
David Herskovic appearing on behalf of the defendant appellant, Delane Lambert. This matter has been thoroughly briefed by both myself and sister counsel. I don't think there's anything I can add to the to an argument that hasn't already been stated in the brief. I would be more than happy to answer any questions this honorable court might have. Otherwise, we would just rely on the brief.
I don't see any questions. What do we hear from the appellee?
Good afternoon, Your Honors. May it please the court, Elizabeth Matthews on behalf of the people. I just had one brief issue I'd like to address, OV7. I did cite People versus Hardy in my brief, but I'd like to note when I was reviewing, I noticed it was overruled by a case People versus Liddick, which is 225 Michigan App 486, and that's a 2021 case. But we still believe, despite that case, that OV7 was properly scored based on defendant's egregious conduct. So unless there are any other questions.
Nope, I don't see any. Thank you.
Okay, thank you.
Yep. Herskovic, anything further?
No, Your Honor.
All right. Thank you both very much. That matter is submitted. Turning now to item number 23, that's Trinity Health Michigan versus City of Kentwood. Item number 367419.
Feel like we should have taken a lunch break before we get into,
Civil cases?
before we get into property tax.
Yes. All right. I never thought I'd look forward to a property tax case.
May it please the court, Ryan Shannon of Dickinson Wright on behalf of the appellant, the city of Kentwood. And I did notice you stacked both of the property tax cases together after the 11 o'clock docket. So this has been fully briefed, so I don't want to go issue by any means. What I do want to focus on out of the gate, and I'll just briefly set the stage, but I think there's an important concept that sometimes when we reread the briefs 2 years after the fact, we say, well, we as tax lawyers know that, but does the panel necessarily know that? So to briefly set the stage, this matter concerns taxable status of a big building in the city of Kentwood, 116,000 square feet. And by our count, there's about 810 little offices, little cubicles in that building. So it's a large office complex. Before this appeal, the posture I think is important to some points I'm going to make down the line. So before this appeal, the owner of the building, Trinity Health Michigan, was using less than 5%, about 4.6% of the building, and was getting an exemption for that. The city said, well, it's a small exemption, we'll give it to you. So the lion's share of the building was being taxed. It was on the rolls, it was admittedly vacant, it wasn't being used. What changed in 2020, which is the first year of the pandemic, right during work from home, is the owner of that, the owner's parent company, Trinity Health Corporation, now said, well, we're going to move in and occupy those remaining 770 cubicles. We're going to use the rest of the building. And we think we should get an exemption because we're a nonprofit charitable institution as well. And the city said no. And then it went through full discovery and briefing on cross motions for summary before the tribunal. And the tribunal sided with the appellees, but then sua sponte added the 2022 tax year. Now this, like I said, there are multiple reversible errors. I'm going to focus on four chiefly here. So first, the tribunal added 2022. That was in plain error. There was no motion practice on it, no evidence before the tribunal on that. Tribunal plainly applied the wrong standard. And then focusing on the substance, once you get through those two issues, focusing on the substance and applying the right standard, The appellees not only didn't show there was no material issue of genuine fact that would support a C10 in their favor, they didn't even carry the burden on the issues of use and that they actually occupied the property.
So just to put my cards on the table, kind of. I think your argument with regard to the corporation not being a charitable institution are fairly weak. I think the question of occupancy is an interesting one though, because as I read the statute, it's not only occupancy, but the occupancy has to be for the sole purpose for which the charitable institution has been organized or established. How do we know and how do we figure out and how do we establish whether all of the non-hospital, the non-Michigan hospital square footage was being occupied for the sole purpose of the charitable purpose?
Yeah, well, so if you look at, and that's kind of where I wanted to start was with the concept of apportionment. That's the concept I'm talking about. Does the panel know that? Right?
Do they typically apportion? Do they typically say, yeah, you're using about 5,000 square footage, the other 195,000 you're not using, so you get taxed on that portion? Is that in your experience, is that pretty typical?
Yeah, and so if you look at like the hospital purchasing case that the tribunal relied upon, now it's a non-binding 1968 case. But in that case, a good portion of that building that hospital purchasing was claiming should be exempt was actually being used by a different entity. It was being used by the Secretary of State. And so hospital purchasing got a portion, it got an apportionment exemption on that part of the building. We cite the Lake Louise decision. It's another 1968 case, but there there was a church camp that had a lot of activity on 330 acres, but not so much on the remaining 1,300, not constant use on that 1,300. Now, what we do know, the evidence in the record is very, I think, pretty compelling on this point. What we do know about occupancy is that in the middle of 2020, Trinity Health Michigan just moves in 90 doctors and then moves them out a few months later, and then moves in a vaccination clinic and moves them out a few months later. If they had 770 people working in there, if they
Wait a minute, I want to separate. So there's the hospital and the corporation.
Right.
So were you talking about the hospital moving these doctors in and out?
Right. So if the corporation is using the rest of the building for its purposes, how come we're not displacing people who are using those offices? The point of the exemption, and I think it really goes to the core of Wexford, it goes to the core of the statutory language of use for the charitable purpose, to your point. We shouldn't be exempting things that are just sitting there vacant. If they're sitting there vacant or only sparsely used, they become an investment at that point. I'm sitting on it to see if it appreciates so I can sell it. And it doesn't go to the point of, the gift that they claim they're giving, the $25 million in consolidated savings across 3 different centers. Well, it could be that 2 of the centers are contributing $26 million in savings. And because this building is mostly vacant and empty, the heating costs and the maintenance costs and everything else are actually detracting from that. That's in the light most favorable to the city. That's a reasonable assumption to make. We don't have anything specific to this particular site showing how it's contributing to the alleged $25 million in savings. What we do know is, and I want to talk a little bit, you thought the arguments were potentially weak about the corporation not being a charity. I want to really focus laser in on factor 5, the idea of successful maintenance, because in the last year prior to the pandemic, if we focus just on 2019 and we focus just on the corporation's financials, they're showing $38 million in revenues after expenses. So that's not a consolidated figure. That's just the corporation.
Right, but there's loads of case law that says that a nonprofit doesn't have to lose money.
That's right.
We'd be driving all of our charities into bankruptcy every year if we did. So the fact that they made money, frankly, the fact that their CEO made, roughly 2.5 million versus, roughly 25 million for a private entity CEO of comparable institutions, I just don't think that gets you anywhere.
Well, I think it does for a couple of reasons. One, if you look at hospital purchasing, right, that entity at the end of the year had $662 in its account. And there was evidence as to where that was going. It was going to use it to buy radiology equipment or other equipment to expand its services. It was minute. $38 million is, I mean, inflation's changed a lot since 1968, but $38 million is far afield from that. And in the year prior, it
Is
was
there any suggestion that they're doing anything other than plowing that into back into the institution, even if it's just to hold it to earn interest, to then use that interest for the good of the charity?
Absolutely there is, because we have 260 subsidiaries under this entity. So the phrase from Wexford is successful maintenance, right? You're allowed to grow a little bit. You're allowed to certainly put the money back in, but that's not what's happening here. We've got a snowball that's getting larger and larger.
I don't understand why does it matter how many subs they have? I mean, it'd be great if this charity was so successful that they had 1,000 subs and were doing charity work all over the place.
Right. And size is not a disqualifier, but the point is, at some point, it's not about successful maintenance. The phrase is successful maintenance. You're allowed to year over year support your
successful
operations.
growth in a charity makes it no longer a charity.
I'm saying it's a factor that you need to look at in terms of, are they actually dedicating things to a gift, which is what Wexford says is relevant. Are you giving a gift, or is it year over year really your primary purpose to grow? And here, what we don't have is any evidence of anything flowing down to the subsidiaries that would constitute a gift. We have evidence that they're charging $50 million a year in subsidiary intercompany fees, that they are paying $30 million in compensation to their C-suite, including incentive compensation. And I think that's really important, because if this were a dividend being paid to a shareholder.
Do you have any case law that says that maintenance means that a charity can't grow?
No, and I'm not saying a charity can't grow. What I am saying is, when you're evaluating under Wexford, the Wexford factors, especially in a C10 context, in terms of saying, is there enough evidence? And you see a charity that cannot demonstrate a gift to its subsidiaries. Year over year is showing actually $38 million in revenues less expenses in 2019. It's $18 million in 2018. And continues to grow. That should support the notion that we need there is a genuine issue of material fact, and that this should continue to a full hearing so we can get a better understanding of, is there actually a discount being applied? Are they charging more than necessary to these subsidiaries for these services? And it goes right to the point of the use of the building. Are they holding this building as part of a growth strategy, or as part of an investment, or for a charitable purpose? So it all ties together somewhat. I don't envy anybody who has to apply the Wexford factors. The Wexford factors are a little bit mushy in terms of, some are binary. The very first one, are you a nonprofit or are you not a nonprofit? Later ones, though, like the fifth factor, successful maintenance, the sixth factor of, you have to be overall charitable, but not necessarily give charity in any given year. Are those supposed to be viewed together? Is there a weighting that's supposed to happen? If an entity like this one, you can't find evidence in the record of that they've ever given a particular gift, that they actually have marked down services to a particular degree or anything else. Well, the sixth factor would say, well, it's not essential that they do, but it should still be weighted against the other elements in the record regarding the amounts of funding that they're taking in and their growth strategy. They've acquired 260 subs. They're growing rapidly. That's a little inconsistent with, again, giving a gift. Growth is not a gift. Any other questions on that point? I want to make one quick point on 2022. I think it's just, again, plain error that for the tribunal to address 2022 on a C10 especially. There's no evidence. When the briefs went in, it was mid-2021. So every tax year is its own animal in tax law.
No party actually asked for
right
summary disposition on 2022, correct?
And that year is still, that's correct. And that year is still pending right now in front of the tribunal in a different docket. So you had the wrong year. You also had the wrong parcel. The parties corrected that on their own. You plainly had the wrong standard applied. And so, when the tribunal looks at things like, was there a gift or was there successful maintenance? Are they charging more than necessary? It says, well, they're limited by federal rules regarding what they can charge, these hospital charges. It's the inflection point of the reversible error is this is not a hospital. The corporation is not a hospital. It doesn't give care. It doesn't give charity. It's not like the entity in McLaren. It's not like the entity in Wexford. It's not even like the entity in hospital purchasing. because it sits at the top of the pyramid. It doesn't have members paying into it. And it doesn't have its residual value go to its members when it dissolves, like the entity in hospital purchasing did. So all those things make this very unlike hospital purchasing, very unlike the entities in McLaren and Wexford in those regards. This is an entity that sells back office insurance collection services, back office administrative services to an ever-growing portfolio of subsidiaries. And we just don't have the evidence in the record that there's a gift here. So I've got about 3 minutes left and I'll reserve for rebuttal unless there are any questions. Thank you.
Thank you.
May it please the court, I'm Deb Ondersma on behalf of the Appalese Trinity Health Corporation and Trinity Health Michigan. I am not an appellate attorney. I am, in fact, a nerdy property tax attorney, so you'll forgive me if I stumble or if I need to look for documents. Because I'm a nerdy property tax attorney, I was involved in this at the beginning, so I can tell you that when Trinity Health Michigan occupied this property for hospital departments, 50% of the property, one entire parcel, was exempt. So that was a misstatement, understandably, since he wasn't involved initially. Also, the first year involved ends December 31st, 2019. That was not COVID. As we all know, COVID hit. We can probably all remember the date off the top of our heads, March 13. You remember getting those. So the first year involved was not COVID, it was pre-pandemic. But the issue here is really straightforward. Can a nonprofit entity providing consolidated services for other nonprofit entities qualify for exemptions from taxes under Michigan General Property Tax, MCL 211-70? I'm going to talk quickly about the things I think you would care about. I know you're well prepared. I've been sitting here. I hear that you know your cases. Standard of review. The tribunal correctly outlined the standard of review, and we all agree. The standard of review is that the moving party must show that there's no genuine issue of material fact. The moving party bears the initial burden of presenting evidence. The opposing party then, the burden then shifts to them to present evidence.
We're looking at this anew, so I don't know that we need to go through the rigmarole of C10, but would you mind addressing the question of how do we determine what the corporation, or that the corporation occupied its portion of the property solely for the purpose of the charitable reason that it was put in, that it was established for or organized for?
Yes, I will do that. And I only wanted to make the point in the standard of review argument that they presented no evidence. The only evidence that's presented in this court, in this case, is evidence that was presented. That actually, I think, is a rather easy thing to prove. To prove, well, there's two things. There's the occupancy that you have to prove, and then there's that it's occupied for the purposes that for which it was incorporated. For occupancy, there are multiple sworn affidavits that this property was occupied, a small portion by Michigan Health, by Trinity Health Michigan, and a much larger portion by Trinity Health Corp. The affidavits unequivocally say that this property, to the extent it wasn't operated, that it wasn't occupied by Trinity Health Michigan, was fully occupied by Trinity Health Corporation.
So if someone walked through this property, would an average person look at portions of this property and say, this is vacant?
Absolutely not.
So they would look around and there's always activity within eyesight. It's not as if there's a large portion that is used for, it's basically vacant or dormant property.
During these tax years, it was absolutely occupied, and that's what the sworn testimony says. He just said that he counted that the diagram that we produced showed 810 cubicles throughout the entire property in multiple conference rooms. The property was occupied. That's the only evidence that's in the record. If it wasn't occupied, they could have produced a counter affidavit. They could have produced an inspection report. They could have produced pictures. They could have produced counter evidence, but they didn't.
Well, maybe I was not clear. My question is less on whether it was occupied by the corporation, but whether all of the property that the hospital was not using, all of the rest of the property was being used solely for the purpose for which the charitable institution was organized.
Yes. So let's go there. Why was Trinity Health Corporation organized? We have to go to their articles, their bylaws, their corporate organization documents. If we look at Trinity Health Corporation's articles of incorporation, it tells us that it's, in addition to being organized for 501c3 purposes, which every nonprofit says, it also says that it's organized, it shall be operated exclusively for the benefit of public healthcare organizations. That's what's IRC, Internal Revenue Code 509A. But it also says, their articles, they're to be exclusively operated for the support and benefit of its affiliates in order to enhance their ability to effectively meet the healthcare needs of the communities they serve, consistent with this purpose. So they are occupied, excuse me, Trinity Health Corporation is organized to enhance or to support and to benefit their affiliates and to enhance their affiliates' ability to present healthcare. Their bylaws say it's organized to serve together in the spirit of the gospel as a compassionate and transforming healing presence within our communities. So what does Trinity Health do with this property? It's all over the briefing. Trinity Health in this particular property, Trinity Health Corporation in this particular property operated what they alternatively call patient billing services or patient access services. The affidavit.
What about Mr. Shannon's argument that it seems odd that as the hospital used more and less of this property, that somehow the corporation was just very, if the hospital for a short period of time doubled its footprint, and that's not his words, it's mine, I'm just hypothetically, they went from, just to use simple math, 5,000 square foot to 10,000 square foot. How would that impact whether the corporation was then fully utilizing all of the Delta property? Because if the corporation was, presumably the hospital just couldn't come in and add 5,000 square footage almost on a whim.
That argument or that question is a really fair question. So I want you to go back in time to what was happening during the months of 2020 when those doctors moved into that facility. During the months of 2020, we were all under a stay-at-home order. So was there a reduction in staff from Trinity Health Corporation at that building pursuant to a stay-at-home order? There was a reduction which allowed those doctors to come into that space. See, Trinity Health Corporation in Trinity Health, Michigan, did exactly what Trinity Health Corporation's articles say they should do. They worked symbiotically. So when Trinity Health Michigan had property it wasn't entirely using, Trinity Health Corporation came in and filled that space. When people got sent home because of COVID, Trinity Health Michigan knew that there was an additional need in the community for doctors, for telehealth services. Doctors were going in there because they were essential workers and performing those telehealth services. If you look at the diagram that they've attached to or included in the reply brief with respect to the immunizations, the immunization space on that diagram is an open space that is not covered by any of the cubicles. It is an open space. So Trinity Health Corporation and Trinity Health Michigan worked together to use that space efficiently. But that's how there was space available. And that also is in the record.
Can I make an analogy to income taxes? Some cities have income tax, right? And when COVID happened, people were working from home and maybe not working in that city. And I think cities have suffered a loss of revenue as a result of that. Why is it different for property tax? If those employees of the corp were not working there during COVID, why shouldn't it have an impact on property tax just like it did on income tax?
Well, there were still employees there. And the affidavits, the sworn affidavits indicate that there were still employees there and that there were still employees there on a daily basis. There were fewer Trinity Health Corp employees and there were more Trinity Health Michigan doctors providing telehealth
Is that
services.
reflected in the tax tribunal's order then? Because, I mean, you are two different entities. And so presumably during this year of flux, that flux should be apportioned. And was that reflected in the tax tribunal's ruling?
It wasn't, because the entire property remained exempt. Did the tax tribunal say, I'm giving the exemption under 211-70 subsection 1 for owner occupied property, or I'm giving the exemption under 211-70 subsection 3, which is to a nonprofit user of a nonprofit owned property? The tax tribunal didn't differentiate. The outcome.
But does the corp and the hospital pay different tax? They have different tax bills?
No, because the Trinity Health Corporation is paying the entire tax bill.
Consolidated? They pay the entire.
They pay the entire tax bill at that property.
And
I'm not sure what you mean.
And it doesn't matter. I mean, if the hospital had 100% or the corporation had 100%, it just doesn't matter. It's the same exemption.
It's the same
and
exemption.
the rates are no different between the hospital and the corp.
There's no difference.
Okay.
There's no difference.
Okay, that's helpful. Thank you.
Hospital purchasing is on point. I understand that it's a 1968 case, but it is entirely on point. Hospital purchasing found persuasive that a membership corporation without capital stock and stockholders, that's what we have here in this case, that doesn't pay interest or dividends, that's what we have here, that compensates only its employees and it's engaged in its daily operations, that's what we have here. This is what we have here. And in that case, a different panel of the Court of Appeals determined that that was sufficient to determine that the LLC or the company that was not providing actual medical care was in fact charitable nonetheless, because despite the fact that that company wasn't providing actual medical care, it was in fact providing a service that allowed medical care, that would relieve bodies suffering from disease, if you will, under element or factor 4 of Wexford. I do want to touch base on the doesn't charge more than necessary for successful maintenance. When the correct 990s are looked at and you compare the assets, the net assets of Trinity Health Corp to Trinity Health Michigan, Trinity Health Michigan owns and operates 5 hospitals in the state of Michigan. It owns urgent care facilities, physicians, all kinds of healthcare facilities. The 990 shows that Trinity Health Michigan has $2.5 billion in net assets, roughly, for all years at issue. Trinity Health Corporation has, if you look at their 990s, between negative 100 million, positive 100 million, and for a third year, going back one more, all of the information in the record, 375 million. So its records show that it decreased the net assets 200 million per each year. But the size difference is important. The assets are held by the hospitals. Trinity Health Corp is a parent that supplies services. Now, let's talk about the $1.6 billion, because that's true. Trinity Health did receive $1.6 billion. If you look at their 990, it's appendix page 469, you'll see that. In fact, you'll see that they had $1.65 billion of income through subsidiary fees and intercompany purchase services. But you'll also see that they had other income, including investment income, government grants, making their total income to $2 billion. That's a big number, right? But if you turn the page on the 990, what you see is that they have expenses that year of $2.1 billion. In other words, not only did the fees charged to the subsidiaries not cover the expenses, the fees plus the other income generated by Trinity Health Corp didn't cover their expenses. They lost funds during that year. So this is what appellees meant in our brief when we said, you can't just say, this is too big. It's a big number. These are big numbers because it's a big charitable organization. They are big numbers, but these big numbers show that their charges, the evidence that is in the record, show that their charges, the fees that are being paid do not cover the expenses.
About tax year 2022.
Tax year 2022 was waived by the appellant.
Let's assume it wasn't waived.
Tax year 2022, the tax tribunal has the right, a statutory right, to add the tax year to an open petition. It was an open petition.
Did you ask in this case, not a separate case, you didn't ask for 2022?
I did not
Was there
ask.
was there any evidence with regard to 2022 in this case?
The evidence that has been provided talks about continuing operations, talks about operations that were operating and continued to operate at the property. Discovery in this case was reopened. So discovery didn't close until January of 2022. So discovery was open past the tax date establishing tax year 2022. They're not prejudiced because the discovery was open. They had the opportunity to conduct discovery. I will reserve any time I have left.
Okay.
I'll be relatively brief here. So what we don't know, what we have no affidavit on from the corporation is anything saying this is how many employees were there, this is how long they were there. During COVID, we pulled this many out and they came back on this date. None of that. What we have initially in their brief was an affidavit that said they, quote, made available, that TH Michigan made available the property to the corporation. So the city then calls them out on that, pointing out there's a gap here. Making available is not the only standard. The statute also says you have to occupy it for your charitable use. The response then was on a reply brief for the first time, an affidavit that says, well, we do occupy it. We perform some of these functions there and we have employees there every day. That reply affidavit still is deficient. It doesn't identify how many employees come in. We're talking 770 cubicles. How many of those are being used? How often? When are employees coming in and out with COVID? And COVID complicates everything here. It creates a lot of fact issues. It also creates a fact issue with, for example, this loss that was referenced, the 1 year where it's 2.1 billion in expenses and 2 billion intake. Well, yeah, in a COVID year, a lot of businesses lost money. That doesn't make them charities. You have to look at the full 3-year period. And I'll just return once again to that. In the year prior to COVID, the last financial information we have was that this entity took in $38 million more than its expenses. That's what was showing on its Form 990 before COVID hit. The last point, the last point I'll make is on this. You had raised earlier, Judge Schwartzel, the $25 million for-profit entity, what they were paying to their CEO. That's one data point in a vacuum. So we don't have an expert out there on executive compensation. In discovery, they resisted giving us any information on executive compensation, saying, well, it's a trade secret and we go through a process, we can't share that, rather than move for protective order or anything else. But we have a gap, basically, because all we have is one data point about one for-profit versus what they're actually paying here. I think all you need to know for the city to survive C10 on that is there's admittedly incentive compensation here. There's an amount being paid, and it's not just one executive, it's multiple executives, and it exceeds fully for just that one CEO, the full tax at issue. So there's a direct through line. The tax exemption here is going to go directly into the incentive compensation paid to that executive. It's going to go in their pocket. The citizens of Kentwood and the state are going to be incentivizing incentive compensation.
Wait a minute. Are you suggesting that the compensation is tied to the size of the exemption? So if there's no exemption here, the officer gets zero or some low number in terms of incentive compensation?
So it's incentive compensation, and what we have in the record doesn't explain the nature of it all that well.
But I mean, you just made an assertion that the size of the incentive compensation is what the exemption would be.
Yeah, let me make sure I'm being clear on this. I certainly don't want to overstate things. But what I'm saying is presumably the amount of that incentive compensation has something to do with the amount left over in the coffers at the end of the year. And this exemption has to do with the amount left over in the coffers. There's more money left over for that incentive
I think
compensation.
that's a bit of a stretch, but.
Well, I don't know how you get incentive compensation otherwise. It's got to be based on something about how much can we pay. But the broader point is it's private inurement. That is pecuniary gain. If that was a dividend to a shareholder, it would be disqualifying. It shouldn't be any different when it's incentive compensation. Any other questions?
No, I don't see any. Okay.
Thank you.
Matter is submitted. Thank you very much. We're going to take about a 5-minute break.
Court of Appeals, State of Michigan is now in session. Please be seated.
Well, good afternoon. Turning to the next case, which I show as item number 24, DRSN Real Estate GP LLC versus City of Grosse Pointe Woods. Item number 371826.
Good afternoon. May it please the court, Dan Stanley of Honigman LLP on behalf of the appellant cross appellee DRSN Real Estate GP LLC. As an initial matter, I'd like to reserve 10 minutes of my time for rebuttal. I've appeared before the court many times. I know you've got a case evaluation up there. You've probably got a proposed opinion up there. You've read the briefs. I'm not going to recite everything in the briefs. I'm here primarily to answer questions. If at any point in my presentation, I'm just going to hit the highlights. At any point in my presentation, you have any questions, I'd urge members of the panel to ask. That's the reason we're here. The issue for the tax tribunal below was what was the true cash or market value of DRSN's senior housing property in Grosse Pointe Woods as of December 31, 2020. Now, DRSN's property was partially financed with tax-exempt bonds. As a condition of receiving those bonds, the Internal Revenue Code required that 20% of the independent living units at that property be rented to low-income individuals. And that condition exists until at the earliest, September 2031, even if the bonds get paid off.
Hang here for a moment. You
Sure.
said, is it set aside for, or is it rented to?
Well,
Or is there a difference?
I don't think,
I've seen them, I've seen
sure.
it's being cited differently.
Right, I believe rented to. So there are 77 independent living units, 16 of which have to be rented to low-income individuals. It doesn't have to be the same 16, but at any one time, 16 have to be rented to low-income individuals. So, yeah, I don't think, individual units aren't necessarily set aside. It's just that 16 of the units have to be rented to low-income individuals. So that restriction was put into a recorded land use restriction agreement that again, it's recorded, runs with the land and binds anybody who purchases and owns or operates the real property. Now, the market rent for independent living units as of December 31, 2020 was approximately $4,400 a month. And the 16 restricted units had to be rented to residents who earned less than $2,300 a month. So clearly you're not going to make $4,400 a month from those units. And in fact, the evidence in the record is the low income units rented for about $700 a month. So the impact of the land use restriction agreement is a reduction in income to anybody who owns or operates this property. To value the subject property, the tax tribunal below used the replacement cost approach to value, under which one determines what it would cost to build a new hypothetical replacement facility that's similar to the subject property, and then you take into account differences between that hypothetical facility and the actual property. So for example, the hypothetical facility is new, the subject property is not, so the tax tribunal adjusted for age. They took roughly 10% off for the buildings and 35% off for the land improvements to adjust for the difference between the hypothetical facility and the subject property. But
Is replacement the correct methodology here?
Yes, I believe so, Judge.
Okay. So we're not looking at income, we're not looking at sale, we're just looking at replacement.
Well, the cost approach, you can do a replacement cost approach. I thought you were getting replacement or reproduction. Replacement is the cost it would take to replace the property with a hypothetical facility that has that's similar. Reproduction is another cost approach in which you do it brick by brick.
I'm just wondering, you know, the true cash value, there's usually 3 ways you can do that.
Sure.
The tax tribunal took one approach. I'm just wondering, do you agree that the other 2 approaches, for whatever reason, just aren't relevant here?
No, I don't.
Which
don't,
is the best one we should be
I
using?
don't agree with that. But you know, the case law is pretty clear that the tax tribunal has discretion to pick which approach to value it wants to use and which approach it believes adequately or best reflects the value of the property. Now, you can use the cost approach. We're not arguing the tax tribunal cannot use the replacement cost approach or that it must use another approach. We're arguing you can use the replacement cost approach, but you have to take into account the impact and value of the land use restriction agreement. And in fact, the error that the tribunal made can be seen by the fact that it hypothesized a hypothetical property that didn't have a land use restriction agreement, and that's what it valued. And it would have come to the same value if there was an identical property to this property across the street that was not restricted.
So under your view of the replacement cost approach, do you believe that the tax tribunal should have taken into account both the restriction that runs with the land, but also the beneficial financing, you know, and I forget what it was, like they didn't have the interest on the bonds were tax exempt or something like that. So they got, that was the deal. They got more favorable financing, but then they had to agree to this restriction that ran with the land, correct?
Yes, at the time.
So under the replacement methodology, as you envision it, the tax tribunal, would the tax tribunal take into account both of those under a proper approach, both the restriction, but also the tax exempt benefit?
No, and here's the reason why. Because the evidence in the record is there was no benefit. When the bonds were issued in 2019, they were tax exempt bonds. They were issued at 6%. And so at the time, December 31, 2020, our valuation date at issue, interest rates were historic lows. Mr. Allen testified, it's in the record, let's see, the third volume, I think it's page 85. He testified, and his appraisal has the interest rates. Market interest rate was 4.65%.
So did your client just get, make a bad deal because
No, back in 2019, it didn't. But we're looking at what somebody's going to buy the property for. And when they buy the property, they're going to get their own financing. They're not going to assume 6% bonds when they could just go out to the market and get 4.65. So they're going to get, as Mr. Allen testified, that no rational purchaser is going to assume those bonds. And again, there's no record evidence that the bonds even were assumable. Anybody who purchases the property is going to go to the market and use 4.65% interest rate.
Let me ask you this. What you're bringing up is an empirical question. Back in 2019, what were the rates? Looking at this from a theoretical perspective, could the tax tribunal consider both? Whether there was this beneficial financing that had an effect on the cost, as well as the restrictions that went with the land, whether that had an effect on cost. It's just here. So one, would that be appropriate? And then two, because of the facts of this case, that first issue involving the tax benefit wouldn't come into play because the rates are different.
Yes,
Okay.
I agree with that, Judge, that the tax tribunal, can in such a circumstance could look at the benefits, could look at the detriment, and it should weigh those. But they have to do it based on the evidence in the case, and in the record in this case, there's no benefit. That's the only evidence. And where this comes into cost, when you do a cost approach, you come up with a cost. That's not value. Right? Value is what somebody would pay for it. And in order to account for value, the magic step is called accounting for obsolescence. Obsolescence looks at, okay, what aspects of the property does it have that the market doesn't want or doesn't desire? One of those aspects is a land use restriction agreement. And so, as I said, the tribunal's value might be correct for a identical property to the subject property that was not land restricted, but the subject is. And when a market participant looks at the property and goes, well, which one of these would I pay more for? The answer is obvious. I'm going to pay more for the one that's not restricted because I get more money, I can get more income. But the tribunal never addressed that. The evidence in the record is that the effect on values between $2.1 and $3.1 million. Our appraiser, Mr. Allen, used a spreadsheet which we reproduced in full, and it's in our brief, where he capitalized the rent loss and came up with $3.1 million. The city's appraiser, Mr. Widmer, had in his work file a virtually identical spreadsheet. Again, we reproduced it in our brief. He came up with $2.1 million. So you can't just ignore it.
When do the conditions end?
In the earliest September of 2031. The tribunal had, in its opinion, had 3 paragraphs that addressed the land use restriction agreement. We quoted those verbatim because we wanted the court to see them. We addressed those point by point in the brief. I'm not going to go through them all, but unless there are any questions. So the city claims that the tribunal should have granted its motion in limine based on res judicata or collateral estoppel. But the tribunal properly denied that. The issue in the prior case was what's the value as of December 31, 2016. The issue in this case is what's the value of December 31, 2020. There was no holding by either this court or the tribunal that the land use restriction agreement could never impact the value, just that it hadn't been proven in the 2016 case that it impacted the value. And in fact, this court in the prior case noted that there were evidentiary deficiencies by DRSN's appraiser, Mr. Rasmussen, in that prior case, because the rents he used, the restricted units are only independent living units. And the court noted, well, the rents Mr. Rasmussen used in the 2016 case none of which were for independent living units, none of which were located in Michigan. He hadn't inspected any of them. And 6 of his 8 rent comparables were for skilled nursing units that had rents capped by Medicaid. And so the court held that, assuming arguendo, that the land use restriction agreement is analogous to a deed restriction with respect to the effect on the real property's value, Menard does not help petitioner overcome the other weaknesses of Rasmussen's data. And as the court, so in this case, however, the data is different. The court merely held in the prior case that, and the tribunal held, you hadn't proven it as to 2016. That doesn't foreclose it for future years. And as the court noted in the Wayne County case versus Detroit, which is the primary case that the city relies upon for its res judicata and collateral estoppel arguments, in order for either doctrine to apply, the material facts have to be the same. In this case, the testimony and evidence was very different, and specifically, all of the evidentiary deficiencies this court identified were either addressed or don't exist in this case. Both appraisers agreed what the market rent was for independent living units within a couple of dollars. They're both about $44.50 per month. Both of them used independent living comparables. There's no allegation that they didn't inspect them or that they were out of state. And another thing that changed from the prior case, Judge, as I noted, interest rates had dropped. So what may have been beneficial bonds, tax exempt bonds in 2019, no longer beneficial as of 2020, when the interest rates were 4.64%. So anybody purchasing them, even if they could assume the bonds, wouldn't get a benefit. They would actually lose money, so they would get their own financing, as was testified by Mr. Allen. That's transcript volume 3, page 45. And finally, the city's argument that the tribunal improperly denied its motion in limine based on res judicata and collateral estoppel is just plain wrong, because in order for either doctrine to apply, the material facts have to be the same. The tribunal has to determine the material facts based on the evidence in the records. So you can't really do a motion in limine to exclude evidence to prevent the tribunal from figuring out what the facts are. And so we argue that the tribunal properly denied the city's motion in limine. So for the foregoing reasons, the reasons given in our brief, appellant respectfully requests that the court reverse the tribunal's decision and remand this back to the tribunal for consideration of the impact on value of the land use restriction agreement. Any questions? Thank you.
Good afternoon. May it please the court. Seth O'Loughlin on behalf of Applee and Cross Appellant, City of Grosse Pointe Woods. I appreciate that 6 briefs have been filed in this case, and they have all been reviewed. So I simply want to highlight what I believe to be the most relevant points. Starting first with the claim brought by appellant as to the land use restriction agreement, that argument is essentially a value argument. It was a value argument advanced by its appraiser, Mr. Allen, that said it will apply for this many years. This is the impact on value. And one thing that I think the tribunal made quite clear in its decision is that Mr. Allen's valuation analysis is totally flawed and unreliable. And if the land use restriction is a factor of value and his analysis is unreliable, the tax tribunal should not have to account for that in its final opinion and judgment. And I think there's also the assumption that, look, this land use restriction will carry forward, but as the record shows.
Before you get into that, you said the methodology was wrong. What was wrong about it?
Well, the methodology that was wrong about it, as I set forth in my brief, is that what Mr. Allen used is a going concern rent. And so the going concern rent is going to be rent attributable to, yes, in part the real estate, but it's also rent that goes to the operator. It's rent that goes to intangibles, goodwill to the business, for instance, that, this is a great property run by a great operator that influences the rent. But when you're determining true cash value, you're trying to only use the rent attributable to the real estate. So it'd be like saying that, well, we think the market rent, and to be clear, the market rent that Mr. Allen determined was for a going concern. So he said, this is not just for the real property, but I'm going to deduct it solely from the real property value.
Wouldn't the restrictions go with the real property? I mean, even if the building was demolished tomorrow, don't the terms and conditions go with the land itself?
Well, that's the assumption a petitioner makes, but the record shows that the agreement can actually be modified and was in fact modified. And there is a whole series of provisions within that agreement about how that agreement can be canceled. In opinion of the bond counsel, so if they write that letter, it goes away. So there's this assumption that undergirds their entire argument that says, look, it is in place. It will continue to be placed. It is inviolable, similar to a deed restriction, but it's not a deed restriction. That's between a buyer and a seller. And this is just
a deed restriction can be changed. I mean, they're often not. I get that, but I mean, I guess I don't see the distinction here. I mean, a deed restriction can be changed under certain circumstances. Fine, their restrictions can be changed under certain circumstances, but they're there now.
Well, I think there's 3 points to be made. Is that a deed restriction was legally defined, and I cited in the brief as between a buyer and a seller. This was between a builder and a financer. So I think from that perspective, there are different components as to that. Now, I agree a deed restriction may be able to be modified, but I've never seen a deed restriction that can be modified by the bond counsel, which is not the buyer or the seller. It's a third party that finances it. And I think that goes to the citation I make that creative financing cannot decrease the value of the property, because to the point you asked earlier, Your Honor, they did get a benefit when they built this property. They got those tax-free bonds. That they sought that out. They went to get that for a reason. And in exchange, this agreement was put in place. Now, whether it persists for the entire time, that's to be determined, but there are mechanisms for it to be canceled. And so the fact that they then go out and get this creative financing, it can't negatively impact the value of the property, because then it provides that owner a benefit not only at the time the financing was acquired, but then carrying forward that another property owner wouldn't receive. And so I think there's several differences between this agreement, which is not a deed restriction. The tribunal never said it was a deed restriction. That was merely an argument that appellant advanced and that we disputed at hearing. Now, I also want to address the issue that opposing counsel raised that this is somehow obsolescence. Now, Mr. Allen never argued it was obsolescence. Obsolescence has a definition. It's either an issue with the property or an external influence, which this wouldn't represent. And frankly, Your Honors, I believe that the tribunal well expressed their reasoning as to this. It was an argument advanced by appellant. They didn't offer sufficient valuation evidence. The fact that Mr. Widmer, our appraiser, had a pro forma in his work file doesn't provide support. It's the equivalent of a case that you consult when writing a brief that you leave out. Sure, it's in your work papers, but you didn't think it was relevant enough to include. I want to now, and for those reasons, I believe that the tribunal's decision is well reasoned and should be affirmed, because what is the alternative? The alternative is that the case is remanded, and then what happens? Because the tribunal already said, look, the evidence in the record, it's not sufficient for us. It's not persuasive. It isn't relevant to consider. So then what does the tribunal do? It's a problem that petitioner has not addressed. And I want to move to our cross appeal, Your Honor, and to the issues of res judicata and collateral estoppel. And in making these arguments, I am cognizant of the fact that every single year there is a new cause of action. There is a new assessment. There is a new harm that can be appealed. But the cases from this court, unpublished, sure, do make clear that res judicata and collateral estoppel can apply to the tribunal and do in fact apply. Now, the method that they apply is somewhat specific to the tribunal. As I cited in the valuation context, there's the case that says, look, what happens in the prior year, that value, it doesn't control what you do in the subsequent year. But you have to at least give respect to that decision and say, okay, if the value is X in one year and half of that in the next year, the tribunal at least has to explain why. They're not bound by it, but that previous decision has some finality. And I think more importantly is the Detroit case that talks about an exemption. Now, an exemption is not a land use restriction agreement. I understand that. But I do think the fact that in the previous iteration, the tribunal looked at this and they addressed the threshold issue of, is this something that should be considered when determining value? That's the issue. It's not what is the value of the land use restriction on the previous date. It's should that even be considered under the legal framework of what true cash value is. Now, appellant had a full and fair opportunity to litigate that in the previous case. They did. The tribunal looked at it and they said, well, we don't think, or we don't see that they have carried their burden of proof to show that it does. Now, they brought the same issue up in this case. And the tribunals I cited in my brief, the reasoning, the conclusion by the tribunal are essentially the same. We are addressing the same issue year after year, which is the entire point of res judicata and collateral estoppel, to say, look, if this is addressed, if you had your bite at the apple, you had your opportunity, we can't be doing this every year. And I think it's especially true in the context of value, because every subsequent year after the 2021 year is on appeal to the tribunal. They're waiting in abeyance pending this case. So let's say we go, this court affirms the case. They say, tribunal, your decision is good. We're not going to disturb it. And in 2022, the land use restriction, if it's still in effect, the tribunal looks at it and goes, okay, well, this should apply. You then have two subsequent tax years, if the agreements are the same, where the value is radically different. And that shouldn't be the way this works, where it's another bite at the apple. Now, if material facts change, of course you get to revisit it. But as counsel conceded on the record before the tribunal, this was the same land use restriction agreement in all material attributes. So we should not be here again litigating the same issue before this body and before the tribunal on appeal. And with that, Your Honors, unless you have any questions, I will rest on the briefs. Thank you very much.
Just a few points. Judge Schwartzel, you're exactly right. When opposing counsel said, well, you've got to allocate the income loss between the real property or the going concern. All the income loss is attributable to real property. It's a real property restriction. Anybody who purchases this property, it doesn't matter whether it's, going concern A LLC or going concern B LLC or GM, whoever purchases this property and operates it is bound by the restrictions in the recorded real property, and it's an aspect of the real property. It's all attributable to the real property. The opposing counsel argues that the agreement could be modified or canceled, not the provisions regarding the rent to low-income individuals. That's required by the Internal Revenue Code. With the bond counsel provision is, yeah, if you get an opinion, it's quoted in their brief, it's actually in the record as well. If you get an opinion from bond counsel saying that compliance with that restriction is no longer necessary to keep the bonds tax exempt, then you can quit doing it. But nobody's going to issue that opinion because the Internal Revenue Code hasn't changed. Well, I guess no competent bond counsel would. The IRC, the Internal Revenue Code, requires these conditions. And this is a regulatory agreement exactly like the one that the Supreme Court said had to be taken into account in Meadowlanes. And in fact, the record's clear that both MSHDA and the IRS audit DRSN to make sure that they were complying with these restrictions. And then with regard to some of the things that opposing counsel said the tribunal determined, again, we quoted what the tribunal determined regarding the land use restriction agreement is only 3 paragraphs, all of it verbatim in our brief. It never said that, I mean, it said what it said, but I don't think it said what opposing counsel said they said. So I think you have to look at what the tribunal held regarding it, and none of the arguments it used for its failure to account for the restriction are valid. Any questions? Thank you.
Thank you. All right. Thank you very much. That matter is submitted. Turning now to item number 25, In Re Ireland Miners 378111.
Last but not least.
David Delaney for the appellant and respondent father. I see justice, mercy, and humility. Am I in the right place?
Yes.
Very good. I'm confident you've read through the briefing, which was not extensive in this case. It's really a rule of evidence matter, a jury trial in which social workers admitted medical evidence that a 2-year-old had tested positive for marijuana and trazodone in a jury trial in a child protective proceeding, which is the adjudicatory phase where the rules of evidence apply. That's unfairly prejudicial. Earlier in one of the cases today, I think Judge Boonstra asked about how do we know what the jury was looking at? How do they know what they evaluated? Well, in this case and in this jurisdiction, the judge allows the jurors to ask questions, and they did. And the juror said, was it gummies? Talking about marijuana. So the juror and the jury was looking at this from the vantage point of, for the truth of the matter asserted. The state in this case indicated that it was the effect on the listener, which was not a fact and issue. I mean, the effect on the DHS worker really isn't material in this case.
What about what the caseworkers observed? I mean, they could certainly testify about what they saw, and I think they saw some stuff that was troubling. Well, so even if we agree with you that the drug-related evidence shouldn't have come in, was there enough other evidence that this was a harmless error?
Yeah, I anticipated that question. But look at the petition, which is in the lower court file in this case. And the other evidence related to a cluttered house, some ammunition, which was separate from a firearm that was in the house, and some lethargy. They may have observed some of that. But the state simply could have called the medical testimony, bring the doctors in, bring the technicians in. Why not do that? But you're left to distinguish between what did the jury base its determination on, which was substantial risk of harm.
Was there an unsecured handgun?
That was not in the premises. It was in a safe that was not locked. Yeah. So, and I agree. When you look at these cases, the jury doesn't make a specific finding like kidnapping your first case. They just come back and say substantial risk of harm. You don't really know what it is. But when you have that type of evidence, when a jury speaks up like that and says, was it marijuana, was it gummies, then you know. I mean, that's the top of the list, really. And I agree with that. If the medical evidence came in through professionals, the jury's going to find jurisdiction. There's no question about that. I mean, nobody here would ever advocate for a 2-year-old ingesting those items. And if it's true, it's probably abuse and neglect. but I don't have the opportunity to cross-examine these medical professionals. I presume their testimony was probably going to be correct, but what if it wasn't? What if I could show contamination? What if I could show that they'd made a mistake? I didn't have any of that. But there's no question, I try these cases all the time, that in this case, the jury weighed its hat significantly on the issue of the trazodone and the marijuana. And keep in mind that the next phase of this case will either be return of the children or termination. And at termination, which is a bench trial, the rules of evidence don't apply. So the court can simply adopt this testimony through a social worker and terminate my client's parental rights. That's why it's unfairly prejudicial. And if the court affirms, whether it's published or not, the state attorneys will look to this case to say, see, we can admit hearsay. What's the limit? If you put one social worker on at a jurisdiction trial, and that social worker testifies to complete hearsay from top to bottom, then this case would stand for that. And they could say, well, there's other evidence in this case, but that other evidence was the cluttered home and some ammunition and things like that. I don't think the jury, and I tried the case, weighed those factors. Their questions didn't suggest that. And as soon as that juror asked that question, I knew it was over. They're going to find jurisdiction. They do most of the time, but it has to go back and be vacated because the state simply could have called the medical testimony rather than get it through. And think about that. The social worker is testifying to a medical test result well outside their province. That was done in Grand Rapids by doctors or tacticians. They examined the child. That was the most important evidence in this case. And the social worker can't testify to that. And the effect on the listener can't be a basis to admit that evidence.
I know, this isn't something that we're going to consider for this opinion, but I note that the jury trial was almost exactly a year ago. Do you know what the status of the proceedings are now?
That's a good question. The father is still, if you will, in the crosshairs of this case with the judge. A termination petition has not been filed. The mother is doing much better, not my client. So the children might be returned to the mother, but they could, if the father doesn't survive this case, terminate his rights. Then during this case, they had another child. So that case was set for jury trial on Monday. And I told the judge, I'm going to be in the Court of Appeals on Wednesday. Why don't we wait to see what they say? Because absent this appeal, they would simply repeat the proofs. Even though that child was born last year after this happened, treatment of one child can be considered treatment of another. So they would simply put in the same proofs, the same hearsay, and a jury is going to grant jurisdiction, which they do. I mean, when juries have abuse neglect cases, they want the court to have jurisdiction because they care about kids. But not this way. This is the most important part, the adjudicative phase. Once the court has jurisdiction, you're now in those crosshairs for termination. And if there was other hearsay that involved, possibly ammunition in a gun safe that wasn't locked, I probably wouldn't be here. But when it's drugs and trazodone and marijuana, the 2-year-old, that's compelling.
Okay. Thank you very much.
Thank you
Yep,
for
thank you for doing these cases.
the work that you put in. It's probably 1 o'clock or 1:30. Have a great day.
And
Thank
you've
you.
been here all day if you heard the kidnapping case.
Yeah.
Right?
Well, it took me a while to figure out that it was the kidnapping case because there is kidnapping, but then once I heard explosives, I thought, okay, but you put a lot of time into that. I'm like, how am I gonna get this court's attention at 1:30 on a trazodone case? So.
Well, and these are, some of the most important cases we handle. So we really do appreciate the effort that you put into it. It's very helpful to us and to the system as a whole.
And vice versa. I'll be reporting to Northern Michigan how hard the Court of Appeals works till 1:30. So have a fantastic week.
Thank you.
Thank you.